We are present in case 24-731, State of Ohio versus Jose Perez. We're here for an evidentiary hearing on a motion, defendant's motion to suppress evidence. Defendant is present. You are Mr. Jose Perez?
Yes.
He is present, represented by Counsel Brad Wolf. The State of Ohio is present, represented by Assistant Prosecuting Attorney Lawrence Gagarich. All right, anything we need to address for the record before we get started for the state?
Nothing, Your Honor. Did you want me to do the offer?
Yeah, we'll do 1 second, please.
Okay.
Wolf, anything?
No, good morning, Judge. No.
All right, then let's speak. Let's address that. I think we previously had a pre-trial on this. Like that, what you got? Yeah, we had a pre-trial a few months ago back on this, but at that time, the state made an offer of pleading to count 1, dismissing count 2. I guess I want to find out from the state whether any new offer has been extended and or what the effect of going forward with this hearing has on the state making any offer. Mr. Geiger?
Thank you, Your Honor. The State of Ohio has also extended the offer to the defendant to be able to help himself with a recommendation on count 1, in addition to count 1. The defendant declined. And going forward, as we argue this, there would be no offer.
Mr. Wolf, you're aware of that?
Yes, I am, Judge.
You conveyed that with your, I don't want you to give me details of your conversations, obviously, but you've conveyed that to Mr. Perez?
Yes, Your Honor, that's correct, as described by the prosecutor.
So, Mr. Perez, you were told what the state was offering in this case?
Yes, sir.
And you're rejecting that at this time?
Yes, sir.
And you reckon, as he just said, you realize if we go forward with this hearing that the state indicated there will be no other offer made then at that point?
Yes, sir.
All right. Thank you. Just want to make sure that the record's clear on that. All right, then I'll hear any opening comments from the state, Mr. Gagarich.
Thank you, Your Honor. At this time, State of Ohio would ask you to incorporate our response brief into the arguments.
We'll do that. That's good.
And just as a background, on May 29, 2024, Lake County Narcotics, along with Jog County Sheriff's Department and joint operation, conducted a search warrant at the defendant's home at 250 West Parkway Drive, Madison Township in Lake County, Ohio. The search warrant was obtained through the Common Pleas Court and was executed at the residence. The defendant was, as typical with Lake County Narcotics, they allowed the defendant to leave the residence for officer safety and stopped him pursuant to the warrant, and the search warrant ensued on the house. The defendant ultimately advised the officers of where the cocaine and currency was hidden in his home, and that was recovered. The stop was pursuant to the search warrant, as it's put in the search warrant, indicates for the defendant's person and his vehicle. The defendant's statements after the fact, he was Mirandized and made no clear invocation of his right to remain silent. He volunteered statements, and that's what led to the seizure. Thank you.
Mr. Wolf, for the defense, make any statements?
Thank you, Your Honor. Very briefly. In asking the court to suppress and exclude any and all evidence and statements obtained by law enforcement in this case, I do submit, Judge, that by the end of today's hearing, the state of Ohio will not be able to meet its respective burdens in proving the following 3 issues. Number 1, Your Honor, that the initial stop of my client was supported by reasonable articulable suspicion or was otherwise lawful under the 4th Amendment. Number 2, that my client knowingly, intelligently, and voluntarily waived his Miranda rights after he clearly and unequivocally invoked them multiple times while detained, and that any statements he did make were truly voluntary and not coerced. And that 3, Judge, the evidence later discovered in my client's home as a direct result of the unlawfully obtained statements would have been inevitably or independently discovered absent the unlawfully obtained statements. Again, I submit that the government cannot meet its burden in of establishing those 3 issues. Accordingly, Judge, I ask that all statements and evidence derived from this investigation and case be suppressed.
Thank you. All right, statement calls first witness.
Thank you, Your Honor. Could I get State's Exhibit 1?
Oh yeah, we get both, I think. Sure, and then Stan, can you give this to
Give
us?
that back.
Thank you.
Your Honor, at this time, did you want the separation of all the witnesses, or?
Someone's
Doesn't
moving
matter.
for that?
What's that?
It's up to you guys if you want. Yeah, I'm gonna do that. I'm gonna I'm gonna issue an order for separation of witnesses, so anybody who intends on testifying in this matter outside of the state's representative and defendant need to remove themselves from the courtroom. Until they testify.
At this time, State of Ohio would call Special Agent 91.
And you swear affirm the testimony you're about to give the truth, the whole truth, nothing but the truth.
Yes, Your Honor, I do.
See. Mr. Gagrich, whenever you are ready,
Thank you, Your Honor.
you can ask your questions from wherever. You don't have to do it.
Oh, okay, cool. Oh, will it pick me up?
It'll pick you up.
Okay. Could you identify yourself for the record, please?
Yes, sir. I am Special Agent 91 with the Lake County Narcotics Agency.
And how long you been with Lake County Narcotics?
Approximately 8 years now.
And prior to your appointment with Lake County Narcotics, were you employed?
Yes.
And what was that?
I was a police officer at the Springfield Township Police Department, and following that, just prior to Lake County Narcotics, I worked with the Ohio National Guard criminal analyst, as a criminal analyst.
And is that how you got to Lake County Narcotics?
That is correct.
Were you so employed in May of 2024?
Yes, sir, I was.
Do you have an occasion to effect a search warrant at East 250 West Parkway Drive in Madison Township?
Yes.
And how did that occur?
I was contacted by the Geauga County Sheriff's Office detectives about an ongoing investigation that they had with an individual that had lived at that residence. Once contacted, they presented their case investigation, and we obtained a search warrant for the residence.
And you presented that to the Lake County Common Pleas Court,
Yes, sir.
and was a warrant issued?
Yes, it was.
Showing you what's been marked for identification as State's Exhibit 1. That's,
This one,
yeah.
Thanks.
Showing what's been marked as State's Exhibit 1. Do you recognize that document?
I do, sir, yes.
And where to come from?
It's from the Court of Common Pleas, and it's a judgment entry.
Okay. And that, you were present when that was signed, is that correct?
That is correct.
And what does that, what did the warrant entitle you to search?
The warrant included the vehicle for Mr. Perez, his person himself, and the residence attached to the search warrant.
Is that a fair, that's not the actual judgment entry, of course. It's a copy of it, is it not?
Yes.
Is that a fair and accurate copy of the actual judgment entry?
Yes, sir, it is.
Thank you. So once you received the warrant from Lake County Common Pleas Court, what, if anything, did you do?
Just prior to the execution of it, we briefed up on exactly what we were going to do as far as executing the search warrant at the residence.
And did you set out to execute that warrant?
Yes, we did.
And who was with you?
It was members from the Geauga County Sheriff's Office, Detective Bureau, and agents from the Lake County Narcotics Agency, and also deputies from the Lake County Sheriff's Office, Detective Bureau as well.
Who from the Lake County Narcotics Agency was present with you?
I believe myself, Special Agent 92 and K9 Dalton, Director Pat Hangst, Lieutenant Brad Kemp, and I believe Special Agent 85, and Special Agent 82.
Okay, and you mentioned K-9 Dalton.
That's correct.
Are you familiar with K-9 Dalton?
I am, sir, yes.
What's his role with the Lake County Narcotics Agency?
K-9 Dalton is used primarily for seeking drugs.
He's a narcotics detection dog?
That's correct, yes.
And he's certified, correct?
I believe so.
Who with the Geauga County Sheriff's Department was present with you?
Detective Rob Altimus, Detective Andy Humar, and Detective Steve Derdowski.
And actually, Altimus, Deputy Altimus, or Detective Deputy Altimus, was the co-affiant on this warrant with you, is that correct?
I believe, sir, he was the affiant of this search warrant.
And so you go to the home, what, if anything, you do at that point? You have the warrant, correct?
Yes, that's correct.
Did you execute did you set up on the search warrant prior to having a search warrant, or excuse me, on the house prior to having a search warrant?
Yes, sir, we did.
Okay. And did you have the warrant in hand when you executed it?
I did, yes.
Okay. So tell us how it all occurred.
At the time, from my recollection, we were awaiting Mr. Perez to leave his place of work. A traffic stop, during the brief we discussed, a traffic stop would be conducted on him in Lake County. He would be secured for officer safety purposes. As once he was secured, we would then execute the search warrant at the house.
And typically, Lake County Narcotics does not like the owner of the place to be searched in the home. Is that correct?
That is correct.
So if they're there, you wait for them to leave, or if they're not there, you try to get them before they get to the house.
That is correct.
Why is that?
Destruction of evidence, obstructing anything that we may incur during the execution of the search warrant.
Is it for officer safety?
And is also for officer safety, yes.
What kind of hazards does it create if the defendant is in the residence?
If the defendant's in the residence, it could create destruction of evidence, possible barricade, which would then call for SWAT or an escalation of force, and which could put the individual themselves and the officers on the operation at risk.
And you had a warrant for the defendant and his vehicle, is that correct?
That's correct.
And so you stop the vehicle. What, if anything, occurs then?
Once the vehicle was stopped, we were notified. I was not part of the vehicle stop. I was part of the execution of the search warrant at the residence. Once they had communicated over the radio that the individual had been detained at the time, we then executed the search warrant.
Okay. And who was detaining the defendant in his vehicle?
To my recollection, it was Detective Andy Humar and Detective Steve Derdowski, and I believe they were accompanied with Deputy Shane Hopp, which is the Lake County Sheriff's Office K-9.
And you became aware that the defendant made statements as to where location of contraband, is that correct?
During the execution of the search, yes.
And at what point in the search were you when you were informed of that?
I would go to say approximately midway through the search.
So the search hadn't been completed yet?
It had not been completed, no.
Okay, nothing further, thank you. I'm sorry.
Had you found anything at that point in time when you received that information?
At that time, Your Honor, I'm not sure. I just know that there was multiple individuals searching at that time for other things. I was trying to facilitate communication with those on the traffic stop to the agents searching.
So you said you were halfway through the search when you were advised by the folks at the stop that he had made statements indicating where the drugs were.
That is correct.
Had you found those drugs before you got those statements, before you were made aware of that?
No, we did not. At that time, speaking midway through the search, we had cleared the living room, and I believe agents at that time were searching the bedroom and the dining room and beginning on the kitchen,
Okay.
from the best of my recollection.
Mr. Wolf, cross-examination?
Thank you,
First, I
Your
don't know if you wanted to ask any follow-up to that, I'm sorry.
No, Your Honor, thank you.
Cross-examination.
morning, sir.
Good morning, sir.
Attorney Brad Wolf. I have a number of questions today. I'm going to try to talk slowly and clearly. Please just tell me to slow down or ask it again if it doesn't make sense.
Yes, sir.
Special Agent 91. I just want to start with the report that you prepared in this case. And as a part of your duties, do you regularly prepare incident or investigative reports?
Yes.
Okay. And is it part of your regular practice for officers to make such reports near the time of the events that they document?
That is correct.
And you prepared a written report in this case?
That is correct, yes.
The information in this report, fair to say it was based on your personal observations?
That is correct.
And as far as we know, was this report kept in the ordinary course of your department's regularly conducted business?
Yes.
Okay. And would you recognize a copy of the report if I showed it to you today?
Yes, sir.
I'm going to object, Your Honor. You can ask him questions about it. His report is not a...
Well, he hasn't asked questions yet, but that's where he's going with this. We'll see. I mean, he can identify, but I'm not. At this point, that's overruled.
Okay. Your Honor, I have copies of all of my exhibits for the court. Would you like a copy?
Okay.
Okay. So by that logic, Your Honor, would you prefer me not to make any request to enter evidence during the hearing? Or should I save that for the end?
Do whatever you want.
Okay.
I mean, I guess the point is he's going to start you're going to start asking him to read from his report, and that's not proper. I mean, you ask him questions, and he'll answer them, and if he can't remember them, he can rely on his report to refresh his memory, and if he says something, testifies to something different that's set forth in his report, then you can impeach him with his report, but, I mean, that's how it works.
My only reason for doing so at this stage, Judge, was to ask to enter it into evidence. That's all.
That's fine.
I wasn't going to have him read from it, but.
Okay.
Special Agent 91, I've handed you what I've marked as Defendant's Exhibit B. Is this a true and accurate copy of your report? Take as much time as you need.
I will say, I don't admit police reports into
Yeah.
evidence. Police reports aren't admissible.
Fair enough, Judge.
I believe so, yes.
And if nothing else, Special Agent, I just want to confirm that this is your full, complete, accurate report.
If this is the one that you've obtained, then yes.
Okay, no additional changes have been made to this document from when you originally submitted it.
There may have been, but I am not aware if there has been.
Okay. Moving on. You're the primary Lake County Narcotics Agent Officer for this investigation.
I was representing Lake County Narcotics Agency for the Geauga County Sheriff's Office investigation.
And if I use LCNA to shorten Lake County Narcotics Agency, is that okay?
Yes, sir.
Okay. LCNA's function was to assist Geauga County Sheriff with their investigation?
They had brought it to us that they were investigating something an investigation that had led into Lake County.
Got it. You're aware that Geauga had begun their investigation well before May 1st of 2024?
I can't recall that.
Okay.
I can't give you an exact date, sir.
If I told you it started around March 2024, their investigation, would that
You would have to ask them, sir. If they had just notified me that an investigation was going, I would have to see something that I documented stating when.
The point of the question was you're aware they had been investigating it before asking you to get involved?
They made me aware.
Okay.
Yes.
Now, we talked about the search warrant that Geauga County Detective Altimus was granted, and according to your report, the warrant was for 250 West Parkway Drive, Madison, Lake County, correct?
Yes.
Okay. And that warrant was granted by Judge John P. O'Donnell in this courtroom, in this courthouse?
In this courthouse, yes.
Okay. Again, the warrant was granted on May 29th, 2024, correct?
Yes.
And have you seen a copy of this warrant? I know that you didn't submit the affidavit, but have you seen a copy of the warrant?
I have seen it prior, but not today in this court.
Okay. If I showed you a copy today, do you think you would recognize it?
Yes, sir.
Okay. A moment, Your Honor. This is the one.
Yeah.
Your Honor, may I approach the witness, and my apologies for not asking.
You may, and you don't need to ask any longer. Thank you. This is very informal, but I appreciate it.
Special Agent, I have handed you what's marked as Exhibit C. Do you recognize this document?
Yes, sir.
Okay.
That was C and Charlie?
C as in Charlie. And are you aware that the search warrant wasn't filed with the Lake County's clerk's office until June 4th?
I'm not aware of. I'm really not following what you mean.
The timestamp on this document, I'm reading that this was filed on June 4th, and I'm just asking if you're aware of that.
If it states here on the search warrant, then I would believe that's when it was filed, sir.
Okay. Would you agree with me that there is no timestamp on this document on any page as to when Judge O'Donnell signed it?
I'm going to object, Your Honor. Right in the document, it says when he signed it,
Where?
in the judgment entry.
Where?
Well, in the warrant.
Can I see it, please? You're
Just
saying it
matter-
says,
May I approach?
you're saying it says what time he signed it on that day?
It says when he appeared before him, yeah.
It says what time?
No, not time, but
Well,
day.
that's what the issue is here.
Oh,
The issue is what
Oh,
time
I'm
did he get
sorry,
the search
I
warrant?
just,
That's where he's going with this.
okay.
The timestamp on there for filing is completely irrelevant. He's trying to figure out what time the search warrant was obtained by, right? That's where we're going?
Correct, Your Honor.
Yeah.
So, Special Agent, if I may, I'm sorry. Do you agree with me that on this search warrant, there is no timestamp as to when Judge O'Donnell signed it?
Yes.
Okay. And you just testified that when you were at Jose's home, you had a copy of the warrant?
That is correct.
I believe you said it was in hand?
It should have been in hand. I'd have to review any type of footage or anything, but I believe so, yes.
Review what?
Any type of footage that we had for body cam, but I did present the search warrant to Mr. Perez's wife.
Do you recall how you received a physical copy of the warrant that day?
It was from Judge O'Donnell. It would be, can you rephrase the question?
Sure.
I'm not sure I'm following.
Did somebody else give you the physical warrant, the piece of paper?
No, once signed, I had the physical copy and then had made copies at the agency after.
Got it. And my
For distribution.
question, and this might be my fault, but how did you physically get the warrant? Did Judge O'Donnell hand it to you?
Once signed, it is handed straight to me.
So, just so I'm clear and for the record, so does that mean you were in the courthouse and Judge O'Donnell handed you the warrant?
Yes.
Okay.
He said he was there when he got the warrant.
Forgive me, Your Honor. Detective Altimus was the one that.
Yeah, but he said he was present with detective when they got the search warrant.
Thank you,
Which
Judge.
we testified to in the rep.
Thank you, Judge. Special Agent, moving on. So, according to your report, it was about 1,400 hours when LCNA agents and the Geauga County agents met to execute the search warrant before the execution, correct?
The approximation of the brief, yes.
Okay. And his place of business is Chem Technologies?
That is information that I received from Geauga County,
Okay.
and I believe so.
And during this period of surveillance before the search warrant was executed, do you remember approximately how long law enforcement was surveilling Jose before they initiated the traffic stop?
I could not give you a specific time, sir. I'm sorry.
Okay. But during that time, is it fair to say nobody observed Jose selling drugs?
I can't say that for everybody else, but for me at the time being on surveillance at the house, I did not.
Well, you're aware of all the resources that went into this investigation, so I guess what I'm saying is nobody told you that he had been selling drugs during this period of surveillance, correct?
not directly.
Okay. Did you have any information at all that during this period of surveillance, Jose
You're talking
was...
about that day? Right?
Yes, Your Honor.
And when you're talking about period of surveillance?
Yes, so when law enforcement was starting to surveil Mr. Perez before the traffic stop was initiated, so that period of time, nobody had conveyed to you any observations of Jose doing anything illegal at that time?
At that time, I do not recall.
Okay. And you indicated that Geauga County and Lake County Sheriff's Office, they are the ones that actually physically stopped Jose's vehicle, correct?
That day, yes.
Okay. You testified it was to conduct a traffic stop for officer safety reasons?
Correct.
Okay. And this might be obvious, but it might not be. So the basis of the stop was not because Jose had committed any traffic violations, correct?
As stated before, for officer safety reasons, his vehicle was on the warrant.
Because he didn't participate in the traffic stop. He testified that it was Geauga County who participated in the traffic stop, so he's asking him to speculate about anything that would have occurred.
He actually spoke to this in his report, Your Honor. And based on the prior testimony...
Overall, good.
So, as far as you know, Special Agent, there was no observed traffic violation that resulted in law enforcement stopping Jose's vehicle?
No.
Okay. And do you know, if you know, was he stopped on the road or was he stopped in the parking lot of Dollar General?
I could not completely testify to that. The radio communication has said that he was stopped in Dollar General.
Okay. Are you aware that after Lake County Sheriff's Office and Geauga County Sheriff's Office stopped Jose's vehicle, that a dog sniff was executed around Jose's vehicle?
I'm not aware of that, I recall it
Okay.
at the time.
Are you aware that the same agents who pulled him over indicated at the time that the warrant was impending?
I can't testify to that, something they said, sir.
Okay. Well, I'm asking if you were aware. I'm not asking if you know what they said.
Okay. No, I've never heard that being said, sir.
Okay.
What was your question? What did you say was impending?
Your Honor, my question was if Special Agent was aware that at the time of the stop of Jose's vehicle, that the agents who stopped him had indicated that the warrant was impending.
That's what you said, the warrant was impending?
Yes.
All right.
Sorry if I was being confused.
No, I just wanted to know if there's any other words you used.
Okay. You indicated that Detective Andy Humar is who spoke with Jose, correct?
I believe so, yes.
Okay. And I think you also testified that Jose was detained for this interview, correct?
That is correct.
Okay. And
I mean, let me step for one second. I mean, you can ask whatever you want, but are these other folks going to be testifying here?
Yes, Your Honor.
Why are we asking him all these questions? He wasn't even there.
I'm just trying to be thorough.
Plus, you're going to
just
ask the same.
yeah.
I'm assuming you're going to ask the exact same questions of the folks that actually were there.
Slightly different, Judge, but regardless, I can certainly try to be efficient.
I mean, you can do what you want. He wasn't there. I mean,
Mm-hmm.
if there's something he says that you believe impeaches one of those other folks, I get it. But
Thanks, Judge. Thank you. One moment, please, Your Honor.
sure. I know it's always hard with the first witness not to want to ask questions.
No, I'm just trying to be thorough, Judge.
I get it.
Special Agent, you testified that eventually, I don't want to misstate your words, but eventually Jose conveyed some information to law enforcement about where the drugs were located in the house, correct?
Specifically in my report, it states that I was told that Mr. Perez had indicated where the illegal narcotics were in the home.
Okay. And were you aware that prior to Jose conveying that information, which eventually made its way to you, that he was Mirandized?
I was made aware later.
Okay.
Yes.
Are you aware that before he made the statement, Jose indicated that he wished to remain silent multiple times?
I was not on that stop, sir. I can't testify to
Okay.
that.
Moving on to the house then. So you wrote in your report, I just want to be clear, that Jose said the cocaine was in the cupboard behind a wooden wall plate located in the kitchen to the right of the stove.
That
Is that
description,
accurate?
that description is to the best of my knowledge of that
Okay.
event, yes.
And then Jose said there was $3,000 hidden in the freezer drawer?
That is correct.
Okay. And then after you learned this information, you and the other agents in the home, you followed through on that information by searching for the cocaine in the spot where he said it was?
In the continuing course of executing the search warrant, yes. We were still searching. So that information had been conveyed to us while we were searching the residence.
Sure, I'm not disputing that. My question is, once you learned that information, then you focused your search on that area. Is that fair to say?
It's fair to say, sir, yes.
And you testified that you received that information about, did you say midway or halfway through the search?
Isn't it the same thing?
I just want to get his testimony correct, Judge.
I testified earlier midway through the search.
Okay.
So could be conveyed as halfway through the search as well. A number of rooms had been searched, is why I described it as midway through the search or halfway through the search.
Understood. Your Honor, I do actually want to inquire about how Miranda was issued in this case, because I think it's very relevant to this agent's function. I just want to give the court a heads up. I did want to put on that line of questioning.
He wasn't there. Well, answer your questions, but if he wasn't, let's see if it's,
No,
if it's based on hearsay, then
yeah, no, well,
go ahead and ask your questions.
yeah, I might, Judge. We'll see how that goes. I have a general question, Special Agent. Is it fair to say you've received training in administering Miranda?
That is correct.
Okay.
Yes.
When you were trained that if a suspect invokes their right to remain silent after being Mirandized, were you trained that the police must stop inquiring about that issue?
From my training and experience, they have said that they want to invoke any of the rights read to them, that they could. That's their right.
Okay, and then once that right is invoked, is it your understanding that as law enforcement, you're to discontinue questioning?
No, I'm going to object, Your Honor.
Overruled.
That if any of the rights are invoked, questioning is to stop.
Okay. You said is to stop? Is that what you said?
Yes.
Oh, I just want to make sure I heard you correctly.
Yes.
Okay. And were you trained that if a suspect invokes their right to remain silent after being Mirandized, that new Miranda warnings must be given if the suspect later initiates themselves?
Yes.
Okay.
I believe so.
Were you trained that if a suspect invokes their right to remain silent after being Mirandized, the police must wait a significant amount of time before attempting to reinitiate questioning?
Yes.
Are you aware of the Lake County Narcotics Agency Policies Number 5 titled Custodial Interrogation in Detention?
I'm going to object, Your Honor.
Your Honor, this document was provided in discovery.
Overruled.
I'm sorry. Are you aware of LCNA Policy Number 5 titled Custodial Interrogation and Detention?
Yes. If you can provide me a copy.
If I showed you a copy, would you recognize it?
Yes.
And the witness was marked as a Defendant's Exhibit F. take your time, but have you seen this policy before? Okay. And in all fairness, it's fair to say,
He hasn't answered, Your Honor.
oh, he nodded his head, I'm sorry.
Yes, to answer the question, I do recognize this form as a policy and procedure of custodial interrogation and detention.
Okay, thank you. Would you agree with me that in this policy, it clearly indicates that a suspect must clearly, knowingly, and freely waive their Miranda rights before police may proceed with questioning?
Your Honor, may I reference the...
You could say whatever you want, but I mean, the law is the law. Whatever the law is what I'm going to apply. I don't know what the policy said.
And I agree, Your Honor, and this is just out of their policy specifically.
Who did this, Miranda? Who did this? Jogger, right?
Geauga Detective Kumar, Judge.
I mean, this is irrelevant to me, but you can ask whatever you want.
And I'm wrapping up my questions on this, but I just want to be clear that, and I just want to make sure you understand that according to this policy, your policy, that a suspect must clearly, knowingly, and freely waive those rights before police may proceed with questioning. Were you aware of this requirement of your own policy, understanding you didn't do the Mirandizing?
Their agency didn't do the Miranda.
Yeah, so I'm going to object to the relevance of this at all.
Yeah, sustained. This has nothing to do with this. I know the law, and the law is what the law is. I mean, I'm going to apply the law. But.
My question, though, is, and I do think this is relevant, based on your policy, if you were Mirandizing anyway...
Objection, speculation.
Let me ask the question.
Well, he's asking him, based
Overruled.
on...
Ask your question, please.
If someone says they're not going to talk after they're being Mirandized, would you have ceased all questioning?
Per policy, yes.
Thank you. Moving on. You indicated that once you learned the cocaine was hidden in the cupboard, you and your team, I don't want to mince your words, but you focused your efforts on the cupboard, on the kitchen cupboard.
Which would eventually have made its way that way, yes.
And if I showed you some pictures of the kitchen and the area where the cocaine was found, would you recognize these pictures?
Yes.
I showed you these pictures. Your Honor, I'm approaching the witness with what's been marked as Defendant's Exhibits M, N, O, P, and Q.
Thank you, sir.
Special Agent, please just take your time, and after you've reviewed these, just let me know. Would the court like a picture of the copies for the purpose of the examination right now?
Sure. Thank you.
Going back to the question, sir, yes, I do recognize these pictures as the kitchen.
Thank you.
Thank you.
So, Special Agent, looking at Exhibit M and N,
Yes,
what
sir.
are we looking at in those pictures?
M is a photograph of the kitchen from facing straight on, and it looks as if N is the same but canted more to the right.
Okay. And
You know, Your Honor, not to, the fact, we're going over pictures that a foundation hasn't been laid for it, there's no testimony other than the fact he recognizes pictures.
Overruled.
Okay, thank
It's
you.
not to present evidence. I mean, we can overrule.
Special Agent, do these photographs appear to be true and accurate of your memory of in Jose's kitchen?
Yes, sir, yes.
Would you submit there's any changes to these pictures from when you observed the actual kitchen?
I don't know what changes, so no.
Okay. Looking at Defendant Exhibit O, what are we looking at here?
Oh, I see. This looks like it would be right underneath the faucet,
Okay.
possibly.
And Exhibit P, could you please describe this photograph?
This photograph would be what we consider an out photograph, I believe.
I'm sorry, what word did you say?
An out photograph, meaning we take pictures coming into the home and then as we leave the home.
Okay. So I use the word layman's terms. So Exhibit P would be after the search of the kitchen concluded? Is that fair to say?
I believe so, yes.
Okay. And then Exhibit Q, what are we looking at here?
This picture is a picture of, would be evidence item number 1,
Okay.
behind the cupboard.
And could you describe what the evidence number 1 placeholder is signifying?
If you have a copy of the inventory sheet, I could identify that, but I do not know it off of the top of my head.
That's fine. Is it fair to say that that's the bag of cocaine that was located?
That's a possibility. I do not have the inventory sheet in front of me, sir. I don't want to testify that it is in case it's not.
Okay. You would agree that the cocaine was found in this void space of the kitchen?
The cocaine was found in a void space. I can't testify that this is the actual number because I don't know if this is the number. I don't want to misspeak or...
I appreciate the thoroughness. Your Honor, if I may have a moment,
You
I
may.
think I have the inventory sheet. Excuse me.
Just ask her for a sticker.
Our exhibit sticker, my apologies.
Excuse me.
All right. Your Honor, I am handing the witness what's marked as Defendant's Exhibit T.
Sorry. Thank you,
Is
sir.
this the inventory sheet you were referencing, sir?
Unless there is another inventory sheet attached to this case. Number 1 says that it is containing suspected, C-O-N-T I would believe is containing suspected cocaine, 1 vacuum sealed plastic bag.
Okay.
Do you have reason to believe there's another inventory sheet?
Sometimes if he had items on his person, they may include another inventory sheet, sir.
Gotcha.
I have
It
other.
could list the same number, if we have one for that one.
Correct. I didn't want to misspeak and falsify
Okay.
if it was
Fair
another number.
Fair enough.
To your point, the only other inventory sheets I have are involving cell phones.
Okay, just two others that
Would you
are
like to
cell
see
phones?
them?
Yes, please. Thank you. Here you go, sir, if you wanted to mark them. But yes, cell phones. That's correct. And that is all of the inventory sheets that you've received?
I believe so.
Okay.
So U and V will be inventory sheets of cell phones.
I'm sorry, Your Honor.
You're gonna mark those?
I can.
Might as well since you referred to them. So U and V, is that what you're gonna do?
Yes, Your Honor.
And those are the inventory sheets of phones, correct?
Yes, Judge.
Okay.
So Special Agent then, looking at Defendant's Exhibit T,
Yes, sir.
and we just discussed this, but it notates a number 1. And the number 1 indicates the suspected cocaine, and you said a vacuum sealed bag?
Vacuum sealed plastic bag is what it states here, sir.
Okay, and number 1, we also see a number 1 in Defendant's Exhibit Q, correct?
I see number 1 placard, yes.
Okay, so it's fair to say that number 1 is by the suspected cocaine that was found.
It is fair to say that
Okay.
this should match up, this number 1, yes.
Thank you. So when Jose said that it was behind a wooden wall plate, I see a knife in this picture. Is that a knife in the
What
bottom?
picture, Q still?
Q.
That could be, yes. Looks like a knife.
Okay. And is it fair to say that there's a piece of the corner wood laying on the floor?
Which part? Near the placard or down by the knife?
Sure, it's a 90-degree piece of wood to the left of the number 1 marker.
It looks like a piece of wood, yes.
Okay, that's laying on the floor?
Yes.
You had to remove that piece of wood. You or your team had to remove that piece of wood to get to the cocaine.
I believe so. I did not remove the wood myself, and I did not watch as whoever, I do not know who, I apologize, removed that wood.
Okay.
There were so many people in that kitchen that I can't testify how it was removed or who exactly removed it. The search team did.
That's fair. You'd agree with me, though, and when looking at Exhibit M and N, this piece of wood, this is not a drawer that opens by itself, correct?
According to the pictures, no, it does not look like it has a handle of any sort, but it does look like a cabinet.
And there's you can't see through it. It's obviously a piece of solid wood as it appears in the pictures.
I could say that, yes, I could
Do you
agree with
have,
that.
do you have the exhibit there?
Yes, sir.
Is it M?
Yes, Your Honor. I have M. I'm looking at
Show
it.
me where you're pointing to. All right. And then the next picture is an N. Show me that. N is a Nancy. So it's that vertical piece of wood that's right in the corner.
Yes, I believe so.
Go
Sir?
ahead, Ms. Rule.
Thank you. So, if you're saying it wasn't you, and we don't know who, would you agree with me that somebody had to remove that piece of wood from your team, presumably, to get to that void space?
I would agree to that, yes.
Okay. And are you aware if someone had to use a tool of any kind to take that down?
Depending on how that particular
I'm
piece
going to
of...
object, Your Honor. He's asking him to speculate. He said he wasn't there. He didn't do it.
Sustain.
You're the lead investigator from LCNA on this operation, correct?
I'm a representative of Lake County Narcotics Agency, sir. I was not the lead investigator on this case.
I don't care if he's a lead investigator. He didn't do it. He doesn't have any knowledge of it, so.
But it's your testimony to say you don't know who took this down.
I don't know. No.
You said K9 Dalton
Yes, sir.
was involved with the search of the house?
K-9 Dalton was there.
Okay.
It was spoke about during the brief to have K-9 Dalton used during the search warrant to sniff the residence.
Okay. K-9 Dalton didn't identify any drugs in the house?
I can't testify to that. You would have to consult the K-9 handler, sir, Special Agent 92.
Are you aware of anywhere in the materials in this case indicating that K-9 Dalton located drugs in the house?
If I did, it would be in my report, sir.
Okay. And would you trust me if I said it's not in your report that he identified any drugs in the house?
It is not my report, but I have not also spoken with the K-9 officer. But the K-9 was there at the residence, yes.
All right. Now, there comes a point where Jose is transferred to the home, correct?
That is correct.
Okay. And do you recall at one point Jose was asked if there was any more drugs in the home?
By whom, sir, may I ask?
I honestly don't know. I think it was Detective Humar and whatever other officers are in a recording we have. I'm just asking if you were aware that at some point Jose was asked if there were any more drugs in the home.
He may have been. I can't 100% testify to that.
Okay. Are you aware that Jose answered that question of if there were any more drugs with the extent of whatever you found, you found?
I don't recall any of that, sir, so no.
Other than the kitchen, as far as you know, were any other pieces of wood or walls forcibly removed?
There's a possibility, but not to my recollection. I don't know what all was removed other than what you see in the picture in Exhibit P for the out photographs.
Okay. Okay. And there's no guarantee that, would you agree with me that there's no guarantee that despite the search warrant, you would have located these drugs without the information from
Objection,
Jose?
Your Honor.
Overruled.
I can't agree with you because that part of the home and that area where the drugs were found had not yet been searched. And that area would have been searched if the defendant had not spoken at all.
Is it in the course of normal execution of search warrants to remove pieces of wood that don't have handles attached to them?
If a dog hits in the area, yes, there's a possibility.
Okay. And there's no knowledge that any dog hit in this area,
I would have to speak to the K-9 handler, sir.
based on your knowledge, though?
That is correct, yes.
I have no further questions, Your Honor.
Redirect examination.
Thank you, Your Honor.
Taking my clear exhibits.
Keep them with Mary. Yeah, there. We just need Mary.
Sorry, here we go.
Just don't want you to take them back if you need the rest of them. Just the ones that you identified at this point.
Okay. Give me the original.
Yes, sounds all good.
There you go.
Have you ever
Hang on one second. Let's just get this.
I apologize.
There we go. Mr. Wolf, what are we doing here?
Sorry, Judge, trying to stay organized. My
I'm
apologies.
trying to move along here.
Yep.
Go ahead, Mr. Guyers.
Thank you, Your Honor. You received the search warrant from Jug O'Donnell, is that correct?
That is correct, sir, yes.
And it was put in a folder and handed to you?
Yes.
When was that?
May 29th, 2024.
When during, on May 29th?
I cannot recall the exact time, Your Honor. What exact time that it was actually signed. I believe it was in the morning.
Was it before the patch, Mr. Perez was pulled over in Geauga County?
To my recollection, yes. It was.
Is it your recollection, or you know the fact that you received that warrant prior to that, the search warrant being executed?
Sir, I received the warrant, and after receiving the warrant, Mr. Perez was traffic stopped, and we set up surveillance on the house.
Right. And who else was there with you when you did it, when you got that warrant?
Well, you said, you said they had it before they executed the search warrant.
Okay.
You're talking about, I don't care about the search warrant on the house. I care about the stop of the car. I know if the search warrant had been obtained prior to the stop of the car.
I believe the search warrant had been obtained prior to the traffic stop of Mr. Perez, Your Honor.
Where were you when you were advised by Geauga County that, you said, I think you testified that you had been advised by Geauga County the traffic stop?
I was conducting surveillance for the house, for the execution of the search warrant, once Mr. Perez was detained.
And when did you get to the house? Did you have the search warrant in hand when you were conducting surveillance at the house?
Yes,
And that's where you were when you were notified that he had been stopped?
yes.
Now, how many search warrants have you executed with K-9 Dalton?
I couldn't put a number on it, sir, but multiple.
And K-9 Dalton, would it be fair to say, is a tool?
Yes,
And that tool has to be deployed,
that is correct.
okay? And you've seen K-9 Dalton work before, correct?
Yes, I have.
Have you seen him find drugs in a car
Yes, I have.
from the outside?
Yes, I have.
Have you seen him find drugs in a house,
Yes, I have.
in cupboards, in walls, that type of thing?
That is correct, yes.
So it isn't like, you know, he looks with his eyes, he's sniffing, is that correct?
That is correct, he's sitting.
And he has to be deployed prior to him finding anything, correct?
That is correct.
Nothing further, thank you.
Read cross-examination as to the redirect and to my questions.
No, Your Honor.
All right, Special Agent, you may return to your seat.
Thank you, Your Honor.
1 second here, please. All right, statement calls next witness.
Thank you, Your Honor. At this time, the state of Ohio would call Detective Deputy Steve Dierdowski.
Detective, Deputy Steve.
Did you want to spell him?
Yeah, please.
Deardowski,
Is that right?
Geauga County Sheriff's Department.
Please raise your right hand. You swear or affirm the testimony about to give the truth, the whole truth, and nothing but the truth?
I do.
Whenever you're ready, you just want to let him get set first. All right, Mr. Geiger.
Thank you, Your Honor. You state your name, spell your last name for the record, please.
Stephen Dierdowski, Deardowski.
And are you employed?
Yes, I am.
How so?
I am employed with the Geauga County Sheriff's Office
And how long have you been with the Geauga County Sheriff's Department?
since 2005.
And what's your duties with the Geauga County Sheriff's Department?
So currently I'm assigned to the Detective Bureau with a focus on narcotic-related investigations, which includes looking into the manufacturing of drugs, the trafficking of drugs, and the abuse of drugs.
And Did you have an occasion to open, excuse me, a investigation into an individual by the name of Jose Perez?
Yes, I did.
And tell us about that investigation.
So in March, end of March 2024, I was contacted by the attorney that represents Chemtech in Middlefield. The attorney said that the company had received complaints of drug trafficking on behalf of Jose Perez and Trey Jones, and asked if the Geauga County Sheriff's Office could look into the matter.
And did you look into the matter?
Yes, we did.
And tell us, how did you investigate it?
So my role in this investigation was I acted as the undercover in this case, and I did that by purchasing narcotics, setting up 7 controlled buys of cocaine from Trey Jones.
Okay, so you didn't use a confidential informant, you were the confidential source, correct?
Correct. Yeah, I set up the purchase and purchased all the drugs myself.
Okay, and so once you had those buys, what, if anything, did you do with that information?
So that information was relayed to the rest of the team working on the case. We also, during the course of the investigation, worked to try to identify who Trey Jones' source of supply was.
And were you able to do that?
Yes, we were.
And who was it?
Jose Perez.
And armed with that information, what, if anything, did you do?
So during the process of that investigation, detectives from the Sheriff's Office and Lake County Narcotics Agency obtained a search warrant for the residence of Jose Perez, in addition to conducting surveillance on Mr. Perez.
And ultimately, that warrant was signed by the Lake County Common Police Judge on May 29th.
Yes, sir.
I'm showing you what's been marked for identification as State's Exhibit 1. Take a look at that. And, let me know if you're done.
That was the investigation.
Complete.
What is contained in State's Exhibit 1?
This is the judgment entry for the search warrant for 250 West Parkway, Medicine, Lake County, Ohio, in addition to the red 2016 Chevy Silverado, registered to Jose Perez.
And the defendant himself, is that correct?
Correct.
All right. So you guys received the warrant, correct?
Yes.
And what, if anything, did you do with that warrant?
So once we received the warrant, we conducted surveillance on Mr. Perez while he was at work, and upon him leaving his employer, we surveyed him on his way home back to Lake County, Ohio.
Okay. So you surveilled him all the way from work to home?
Correct.
And
When you were surveilling, did you get the warrant yet?
Yes.
You went and got the warrant, then you went to his workplace and surveilled him.
Yes. Other detectives had obtained the search warrant, and then there was other detectives assigned
Oh,
to.
you weren't here, I didn't know you missed that.
No, Your
You were here
Honor.
when they got the warrant?
I was not here when they got the
I
warrant.
got confused, never mind.
Detective Altimus was the affiant on the warrant. He also works for the Geauga County Sheriff's Office.
I got confused there, sorry.
so why were you surveilling him?
The intention was to stop Mr. Perez outside his residence and then to conduct a search warrant also at the residence.
All right, so you were going to stop him prior to getting to his house,
Yes, sir.
to keep him from going in his house?
Yes.
Okay. So were you informed that they had a warrant, they're ready to execute a search warrant?
I was.
And who executed the traffic stop on the
Deputy Shane Hopp with the Lake County Sheriff's Office.
defendant? And were you present for that?
I was.
Okay. Tell us about what happened. The car is stopped.
So the car is stopped. So I initially, since I was acting as in an undercover capacity, my intention was to not try to include myself in this, as we still had an active investigation involving Trey Jones. So obviously I was going to help in the surveillance, but the plan was for me to not really get involved any further, just because of seeing my face, my voice, just because we had the active case going with Mr. Jones.
And who was all present with you at this traffic stop?
So present at the stop was Deputy Hopp and Detective Andy Humar.
And Deputy Hopp conducts a traffic stop. What is he driving?
Yeah, marked patrol car.
Okay, so he's driving a marked patrol car. What else is he?
He's also a canine deputy, so he has a working dog assigned to his car.
Okay, so the dog is with him at this time, correct?
Yes, sir.
And what type of dog is he?
That's a German Shepherd.
No, I don't mean
Oh,
that.
a narcotics dog.
Is he?
Is
Is
that-
that what he's trained in?
Yes,
And what is he used for?
for detecting narcotics.
Okay, so
The odor of narcotics.
So he's there at the time with the dog, correct?
Yes.
Okay.
What time of the day is this when the traffic stop happens, if you know, approximately?
Late afternoon, so I believe Mr. Perez's shift ended around 3 o'clock. Then we followed him, so it was approximately drive time from Middlefield.
So he got off work at 3?
Yes, sir.
Good.
So the traffic stop occurs, correct?
Yes.
What happens then?
So, like I said before, I was trying to stay out of the stop, just in my undercover vehicle and away from the scene. Due to manpower issues, Deputy Humar, they had the search warrant for the truck, so Detective Humar and Deputy Hop were conducting the search of the truck, and were present with Mr. Perez.
You were present with Mr. Perez?
No, Deputy Hop and Detective Humar were.
Thank you.
Did there come a time when you had a discussion with the defendant?
Yes.
And tell us about that.
So due to manpower issues, we were, Lake County Narcotics was dealing with Mr. Perez's house up in Madison. It was only Deputy Hop and Detective Humar at the stop. They were also trying to search the truck, at which point I felt they kind of needed a hand. So I offered to kind of stand with Mr. Perez while he was in Deputy Hop's car.
Okay, and did you engage in conversation with the defendant?
I did.
Did you read him his Miranda rights?
I did not.
Okay, who did?
Detective Humar.
Were you present for that?
No, I was not.
Okay. So how do you know that he was read his Miranda rights?
I spoke with, as I exited my car, when I kind of realized they needed some help, I had a very short conversation with Detective Humar.
How do you spell that? Is it H?
H-U-M-A-R, Your Honor.
Thank you.
Okay, so you're advised that he had his Miranda rights read to him and he understood them, is that correct?
Yes,
And who told you that?
Detective Humar.
Okay. So, do you have a conversation with the defendant?
I do.
And what's your conversation with the defendant?
So I initially, like I said before, really didn't want to have too much conversation with him. My plan was not to talk to him at all, just because I was still buying and purchasing drugs from Trey Jones, so I really didn't want my voice or look seen. However, so the first couple of minutes were pretty silent. I was wearing to protect my identity, I was wearing like a full balaclava face mask, which only basically revealed my eyes. While standing there with Mr. Perez, he seemed kind of intrigued, kind of confused by the mask. I identified myself, told him I was a detective with the Geauga County Sheriff's Office. I work narcotics. Then basically explained the case and kind of why we were doing what we were doing. And one of the intentions of stopping him away from his house is to not create a whole lot of attention on his house and try to see if Mr. Perez would cooperate in this matter as to providing any more information where his source of supply is coming from. So one of our goals was to kind of try to do the search warrant on his house in a more low profile than bring a bunch of police attention to the area.
So you're trying to get him to work?
Yes,
Okay. Did you offer the defendant that opportunity?
yes, we did.
And what did he say?
He really didn't seem too interested.
Okay. Did you ask him any other questions?
We asked him several. I asked him about kind of why he was doing this. That was my first lead in to the conversation with Mr. Perez. If he could kind of give us any insight on how he was involved in this, got started in this occupation. We talked about that conversation then led into the service of the search warrant. And I explained to him that, we are going to check the walls of his house. We have canines available. Really don't want to tear apart his house if we don't have to. So we appreciate his cooperation. And if there is anything in the house, just kind of let us know where it is.
So you advise them that you have a warrant, you're about to execute it, and he can, if he cooperates, his house might not get tore up.
Correct.
And that's not have you ever executed search warrants before?
Yes, sir.
And what typically happens at the house when you execute a search warrant at?
You have to unplace a lot of items in people's houses, especially when you're looking for narcotics to find drugs. So you have to go through cabinets, you have to flip mattresses, you have to go through closets, you have to go through clothes, you have to go through freezers.
So you weren't threatening him, you were just telling him this is what's going to happen?
Correct.
Okay. And so does he reply to any of this to you?
Yes, so he did say that he was in possession of cocaine, and he provided me the location of that cocaine, which is like a cupboard / kind of cabinet in the kitchen area.
Did he tell you he didn't want to tell you anything?
No,
Did he ask for a lawyer?
no.
How did he just decide to tell you where all this is?
Based on my questioning before, that, we were involved in this narcotics investigation related to him. We knew he was an active part of this investigation. We were confident that he had drugs inside the house, and that, like I said before, we really didn't want to tear up his house if we didn't have to.
Okay, nothing further. Thank you.
Hang on, you said you initially were asking questions about offering him opportunity to work, he wasn't interested. Then you said you asked him questions about like why he was doing this, how he got started. Did he answer those questions?
No.
When you say no, did he say he didn't give you the answers, or he said I don't want to talk?
He just didn't really respond. I was trying to get into the why as to how he got involved in this, and he didn't offer much of a response.
And then you went into the next area about how you're going to conduct the search.
Yeah. As I recall, Your Honor.
I'm sorry?
As I recall, Your Honor. I believe I started with the why as to how he got involved in this, and then once I was kind of done with that line of questioning, I moved on to, all right, so this is what's going to take place now. They're getting ready to, they're at the house, they have the search warrant.
Mr. Gaggers, any other questions you want to follow up with?
Nothing, thank you.
All right, let's take just a very brief recess, and then we'll resume with cross-examination.
Thank you, Your Honor.
All right.
Get up under the table. Thank you.
Stay there. You have to stay there. No, you can go to the bathroom.
Stan,
Hang on.
sorry. Can my client use the restroom?
What?
Can my client use the restroom?
Absolutely. He's free to do whatever he wants.
Just making sure.
Just make sure you're back here. Go out that door right there. Unlock that door, go out there. Just unlock it. Go to the restroom, come back. Be back here in 10 minutes. They're just standing back there. I gotta make sure this is gonna work.
morning, Detective.
Good morning.
Attorney Brad Wolf. My questions don't make sense or I'm talking too fast, just tell me, okay?
I understand.
Thank you. You just testified that you had a physical copy of the warrant during the traffic stop, is that correct?
No.
You didn't
That's
have?
not what he testified to.
I may have misheard. My apology.
No, I was informed that the warrant had been signed and that the other detectives had a search warrant.
My mistake. To be clear, you did not have a copy of the warrant during the traffic stop.
Me personally, no.
Are you aware if the other detectives had a physical copy of the warrant during the traffic stop?
Yes, I was informed that they had the signed copy of the search warrant.
Are you saying that Detective Humar had a signed physical copy of the warrant?
Detective Ultimus.
Okay. Detective Ultimus was not present for the traffic stop of Jose's vehicle, correct?
Correct.
Okay. So fair to say there were three detectives who were present during the traffic stop.
Correct.
No one had a signed copy of the warrant, correct?
Correct.
Okay. Detective, are you aware that there are a total of 3 audio recordings that the state of Ohio gave to defense, which captured some of the interactions during this traffic stop?
Yes,
Okay. Did you create those recordings?
I did not.
Did Detective Humar?
Yes.
Okay. Were you wearing a recorder of any kind?
No.
Okay. Because you were undercover?
Correct.
Okay. Other than those 3 recordings, are you aware of any other audio, video recordings that either of you 3 detectives created during the traffic stop?
I am not.
Okay, thank you. Detective, you indicated on direct, assuming I heard you correctly, that you were aware that Detective Humar advised Jose of his Miranda rights, correct?
Yes.
Okay. Were you also made aware that Jose said he didn't want to talk?
I was informed he said he didn't want to talk. Detective Humar told me he's really not talking.
Okay.
That's what you were told? That's what you were
Excuse me,
advised by Detective Kumar?
Yes, Your Honor.
So you would be surprised to learn that Detective Humar asked Jose if he wanted to talk 3 times, and all 3 times he said no. That'd be surprising to you to learn right now?
I wasn't present for that conversation.
I get that. But just for the clarity of the record, so you weren't told Jose said 3 separate times he didn't want to talk to Detective Humar?
No, I was not.
Okay, appreciate that. There came a point then, well, let me back up. Would you agree with me that as a law enforcement officer, if a suspect invokes their right to remain silent, questioning is supposed to end?
Correct.
Now, we've been talking about kind of the timeline of the course of events, and did I hear you correctly that you testified that the stop happened sometime in the late afternoon?
Yes.
Okay. And I understand you didn't create any of the 3 recordings in this case, but would you dispute me if I said that the very first recording, when Detective Humar was talking to Jose, that it had a file length of 5 minutes and 19 seconds? Do you have any knowledge to dispute that?
No.
Okay. Just going a little further with this, would you dispute me if I said that according to that audio file's properties, audio recording number 1 would have been created on May 29th, 2024 at 3:58 p.m.? Ballpark, if he left his work at 3, I know you didn't create the recordings, I know I'm interrupting you as you're about to answer, but to make that more clear, would you dispute me if I said the audio recording was created at 3:58 p.m.?
It seems a little late, but
Okay.
it was after 3 o'clock.
And I'm going to ask Detective Humar about it. I know you didn't create it. Go with me though, logically, if it was created at 3:58 and it was about 5 minutes long, then it would have ended at 4:03 p.m.
Correct.
The second recording in this case, would you dispute me if I said the second recording that Detective Humar created started at 4:25 p.m. on the same day?
4:25.
That sound right, just generally, if you're on
No,
the side?
Your Honor, I'm going to object. He didn't create these recordings. He had nothing to do with it.
You're gonna go over this with Kumar, right? Oh, what?
I'm just establishing the timeline here, Judge. I mean,
So you're not, so then when Kumar testifies and you ask the question, it's gonna be sustained for ask and answer.
with all respect to the detective, he's not disputing me, but Detective Humar is the one that created them.
Right, so ask Kumar that. Why are we asking him all this? You're just asking him to do math. So if I told you it happened at 3:58, would you dispute that? No. If it went 5 minutes, that means it's ended at 4:03? Yeah.
That's fair.
I don't,
I can rephrase, Judge. Detective, you said at some point you then had interactions with Jose,
yeah,
correct?
this is good. All right.
Yes.
Okay. And if I said to you that you started having interactions with Jose approximately 22 minutes after Detective Humar did, would you dispute that?
I probably sat in my car because as I testified earlier, the plan was for me not to be involved in any conversation with Jose or my presence because I was still doing my undercover work. I probably sat in my car for 10 to 15 minutes, realized that they probably needed a hand, and then that's when I donned the mask.
I might be getting too focused on the times with you, respectfully. Can we at least agree there was a gap in time between Detective Humar speaking with Jose and then when you first spoke with him?
Yes.
Okay, fair enough. Are you aware, during that gap in time, if Jose ever signed any documentation indicating that he wanted to revoke his Miranda rights?
If he signed any documentation, no, I'm not aware of that.
Okay. Are you aware if he verbally said that he wanted to revoke his previously invocated right to remain silent?
No, I'm not.
Okay. Now, you indicated that, you testified that when you started talking to Jose, he didn't tell you he didn't want to talk. Did I say your testimony correctly?
Can you repeat that?
Thank you, that was confusing. When you spoke with Jose, did you testify that he never said he didn't want to talk?
To me?
Mm-hmm.
Correct.
Okay. But isn't it a fact, one of the first questions you asked him, you inquired whether he was doing this for extra cash. Does that sound familiar?
It does.
Okay. And correct me if I'm wrong, but do you recall saying, how much do you make a year out of this? More than 10, more than 20, more than 30, more than 40, more than 50? Do you remember that line of questioning? Okay.
I do.
And then he said, I'm not answering. Do you recall that?
Yes.
Okay. So you do recall him saying, I'm not answering.
To that question.
Uh-huh. Okay, fair. And then a few minutes later, Jose eventually told you or Detective Humar where the cocaine was located.
Told myself.
Okay. And then isn't it a fact that you said, so the next stage is we're going to go into the house and try to find it. We know it's there. We can run the dogs through, start checking walls, do all that, or you can just tell us where the coke is and we can do this a lot faster. We know you can get to it pretty quick. Do I just need to send a team of guys there to start ripping through the house? Did I say that correctly?
Sounds about right.
about right, or is it any significant difference? I mean, I'm asking you.
No, that sounds correct.
Okay, thank you. And then it's after that line of questioning by you, that's when he discloses where the cocaine is, correct?
Yes,
Okay. And when he makes that disclosure, he's still in the back of the police car?
correct.
Okay, still detained?
Yes,
Okay. And specifically, Jose tells you it was in a natural void spot located behind a lower kitchen cupboard backer. Does that sound correct?
it does.
Okay. And then he said 2 cupboard shelves would need to be removed. Do you
Two
recall
which
that?
shelves?
Sorry,
Covered?
Judge?
You said the word covered?
Cupboard.
Oh, cupboard.
Cupboard. Two cupboard shelves would need to be removed. He told you that information?
Yes,
Okay. And then he told you that multiple screws would need to be removed from the cupboard backer to access the cocaine. Do you recall that?
I believe you just said 2.
Okay. So it's your recollection. He said 2 screws would need to be removed from the cupboard backer to access the cocaine.
That's what I recall.
Fair enough. And then you relayed this information to the officers in the house, or was that a different detective on scene?
I believe I was the one who called. I can't recall who relayed that information.
Okay.
I know there were some phone issues, and we were trying to have them. I think myself and Detective Humar both called the detectives at the house at one point.
Okay.
I couldn't recall who made that first call though.
Fair enough. Appreciate that. After everything we just talked about, and tell me if you recall this, but you actually asked him some more questions. You asked him, it's in a cupboard behind screws. Is it in the cupboard or is it behind the stove? Do you recall that question?
I do.
Okay. And you recall him answering that it was in the cupboard, but you had to take the bottom drawer out and the top drawer out to take the 2 screws out. Do you recall him telling that information to you then?
Yes.
Okay. And then, do you recall shortly after, you asked, is it next to the stove or on top of the stove or on the bottom of the stove? Do you recall that?
Yes.
Okay. And then do you recall Jose answering that question by, he essentially provided a more visual layout of where everything was. He kind of concluded his previous answers, but in answering the question about the stove, he gave you what I would call kind of a layout of where the drugs were located. Did you recall that at all?
Yes.
Okay. And then the last question on this line is, you said, do you recall saying, does the whole back plate come off of the lower cabinet? And then Jose answered, you had to take the lower cabinet and the top cabinet out.
Yes.
Thank you. And again, all of the instructions I just asked you about were only provided by Jose to you after he was informed that his walls were about to get ripped up in the house. He didn't give you this information before that comment.
I never said I was going to rip up his walls. I said, Rick, check the walls. We have dogs.
But these comments were made after you said that.
Yes.
Just one moment, Your Honor. This word of ripping is very important, in my opinion. And you may have also said go through walls, but is it your testimony right now that you didn't say, do I just need to send a team of guys there to start ripping through the house? You previously said you said that. I just want to make sure that was accurate.
Yes.
Okay, thank you. Now, there comes a point where Jose is transferred back to the house, correct?
Correct.
Okay. And there's a third audio recording in this case, as you said you were aware of. And there's a point in it, and I honestly don't know who asked this question, so I'm going to ask you, but there's a point on this recording where somebody asked Jose if there were any more drugs in the house. Do you recall if that was you who asked that question?
I do not.
Okay. Do you know who asked that question?
I do not.
Okay. So if I said to you, Jose's answer to that question was, you found what you found, you wouldn't have any knowledge either way to dispute that?
No.
You wouldn't know either. Fair enough. And then, Detective, as far as you're aware, were any walls in the house removed during the search?
No.
Okay. Other than the portion of the kitchen cabinet, which that's not a wall, so that was bad. Strike that. Other than the corner cabinet piece of wood, which was removed to get to the cocaine, are you aware of any other physical structure in the house being removed in the same fashion?
I am not.
Okay.
So you're not saying it wasn't, you just don't know?
I
And
like
once you were
like
clear
I
on the
testified before. I did go to the house, but
answer-
I was
Right,
really
I get it, I don't know why. So you don't have any knowledge of that?
no. I was trying to stay as minimal at that house as I could.
Thank you. Can I have one moment, Your Honor?
Sure.
Detective, during the initial traffic stop, I believe you had testified there was a canine on scene with Deputy Detective Hop?
Yes.
Okay. That canine performed an open air sniff of Jose's vehicle?
I was in my car at that time.
Got it. So you don't know either way? You don't know either way if the canine performed an open air sniff around the vehicle?
I knew they were going to. I can't recall if we talked about the results of that or not.
Do you know that it happened, the open air sniff?
Thereafter, I do, from reading the reports, but I can't recall
Okay.
at that time.
Okay. And then in learning about the open air sniff after, you learned that the canine did not detect any drugs in the vehicle, correct? If you know.
Learning of it thereafter,
You're aware that a canine sniff occurred of Jose's vehicle, correct?
yes.
Okay. Is it fair to say the canine did not hit on any drugs in the vehicle?
Learning thereafter, I was under the understanding that the dog did alert to the car.
We're asking him questions that he is no, I don't know why we're doing this. You're asking questions of people when they say I wasn't involved at all, and you're asking specific questions about it.
Only because you said he reviewed the report, Your Honor.
Well, I don't care what he read.
Yeah,
I mean,
well-
that's all hearsay. You get the witness that wrote the report then.
Absolutely.
It doesn't matter what his understanding is based on reading a report. That's not evidence.
Okay, no further questions. Thank you.
Redirect examination.
Very briefly, Your Honor. If a canine, have you ever had a canine operate within a search warrant, in your experience?
Yes.
Okay. If a canine hits on a wall, would you tear that wall open?
I would.
If a cash currency dog hit on a wall, would you tear that wall open?
I would.
So what you were telling the defendant wasn't a lie, is that correct?
No, that was what we planned to do.
Thank you, nothing further.
Recross as to the redirect.
No, thank you, Judge.
All right, so you may step down.
Thank you, Your
Thank
Honor.
you.
You know who I'm getting?
No.
I'm sorry? I'm calling next witness.
Okay. It's gonna be Detective Humar, Stan.
Thank you. Please raise your right hand. You swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Excellent.
All right.
Mr. Geiger, whenever you're ready.
Thank you, Your Honor. Can you state your name, spell your last name for the record, please?
Andrew Humar, Humar.
And are you employed?
I am.
How so?
I am employed by the Geauga County Sheriff's Office, currently in the position of detective.
And what are your duties as a detective with the Geauga County Sheriff's Department?
My duties specifically are to investigate, dismantle, and ultimately assist in the prosecution of drug cases, drug possession, drug trafficking, and any cases kind of related that thereof.
Were you so employed in May of 2024?
Yes, I was.
And did you have an occasion to investigate an individual by the name of Jose Perez?
Yes, sir.
And tell us about that investigation.
Yes. On the morning of May 29th, it was determined that we would execute a search warrant. We applied for and received a search warrant in the drug trafficking investigation involving the defendant. The search warrant was signed for the defendant's home, vehicle, and a search of his person the morning, I believe it was the morning of the 29th. And at which point we determined that upon Mr. Perez leaving his place of employment at Chem Technologies in Middlefield, I believe that's Middlefield Village, is we would initiate a traffic stop on his person is once he crossed into the Lake County, Ohio jurisdictional area, being where the warrant was signed.
And before we get to that, before you began surveillance of the defendant from his employment, did you have a search warrant in your hand?
Yes, we did.
Okay, who actually had it?
I believe it was, Special Agent 91 and Detective Robert Altimus from the Geauga County Sheriff's Office.
And they had gotten the warrant earlier that morning, is that correct?
Yes, sir.
And did you have a briefing after receiving the warrant of how this was going to occur?
Yes, we spoke just a couple times with Special Agent 91, with the Lake County Narcotics Agency, and then our Geauga County. This was kind of multifaceted. The goal at the time was to initiate a traffic stop on Mr. Perez's vehicle, also to come in contact with, and if possible, conduct a traffic stop on Mr. I believe it was Anthony Perez, Mr. Perez's son, and then also execute the search warrant at the residence to ultimately search it. So we had kind of multiple facets going at the same time.
So you received the warrant and you conduct a briefing. Is that standard operating procedure?
Yes, sir.
Okay. So you do the briefing and it comes time to execute the warrant. Can you tell us how that all occurred?
Yes. So on, I believe it was approximately 3 o'clock, maybe a little after, a little before, towards the end of Mr. Perez's known shift at Chem Technologies. I was part of a surveillance team that would follow Mr. Perez to eventually back into the Lake County jurisdictional area. Once he made it into the
You know,
Lake...
I'm going to stop you right there. I'm sorry.
Yep.
Who else is with you at this time? You're on the surveillance team.
Yes.
So there's 2 separate teams, correct?
Yes.
And what were the duties of the 2 separate teams? Can you tell us about that?
Yes. Myself, Detective Jodowski, were assigned with Mr. Perez's vehicle, and there was, I believe it was Detective Raymond, and I believe Detective McLaughlin from Geauga County, who were assigned to Anthony Perez's vehicle. We believed at that time, with our information, that they would be vacating Chem Technologies and driving directly back to the house, just based on what we had seen previously in the investigation.
Okay. And so the second team is at the house, I take it?
Yes, technically would be almost a third team at the house, a second team with Mr. Perez. Yes, with Mr. Anthony Perez, and then we were with Mr. Jose Perez.
And who was at the house?
It was a contingency of the Lake County Narcotics Agency. I'm not sure all specifically who was there initially. I know it was a contingency from the Lake County Narcotics Agency.
Okay. And who all was with you on your team?
Myself, Detective Jodowski, and then ultimately we're in contact with the Deputy Shane Hopp from the Lake County Sheriff's Office. He was to initiate our traffic stop.
Okay. And why was he going to initiate the traffic stop?
Because of jurisdictional authority, Shane Hopp is a deputy employed with the Lake County Sheriff's Office. So we were waiting until Mr. Perez crossed into the Lake County jurisdictional area to initiate that traffic stop, ultimately to seize the vehicle in Mr. Perez's person.
Because he's a road patrol officer, correct?
Correct. In a fully marked patrol vehicle.
Right. And what else is he?
He is a canine handler for the Lake County Sheriff's Office.
And was his K-9 unit with him?
Yes.
Okay. So Mr. Perez enters into Lake County and a traffic stop is affected by Deputy Hopp.
Yes, sir.
That's where we're at right now, I think, right?
Yes.
Okay. So at the time the defendant crosses into Lake County and a traffic stop is affected, it's your testimony that you had a search warrant in hand for this, correct?
Yes, sir.
All right, just to clarify, not...
Yes, sir.
All right, so the traffic stop happens. Tell me what happens with that, please.
Yes. Deputy Hopp had made contact with Mr. Perez and removed him from his vehicle, at which point I arrived on scene. And I believe initially Mr. Perez was inside the vehicle, at which point I came up and began a interview with Mr. Perez.
Did you Mirandize him?
I did.
And how did you do that?
Would you like me to recite it?
No,
Okay.
just...
So I advised him who I was, my identity, my name, the agency I was with, and advised him of his Miranda rights.
Did he indicate he understood?
Yes.
Okay, and then you indicated you were about to question him.
Yes.
Okay, so tell us about that.
Yes. So while speaking with Mr. Perez, the initial line of questioning as we went into, I'd asked him about the phones that we had located. I believe Deputy Hopp said there was 2 phones inside the vehicle. I'd asked Mr. Perez how many phones he had inside the vehicle, ultimately determining that there were 2 phones that were both owned by him. At which point I asked Mr. Perez if he would like to speak with me specifically about the ongoing investigation, explain the reason we were there today. At which point Mr. Perez kind of broke contact with me, looked away, looked forward, and then kind of looked away at that time. I kind of break this up into kind of this being the direct line of questioning pertaining to why we were there today. Mr. Perez did not say anything. He looked away, kind of broke eye contact, at which point I asked him if he didn't want to speak with us about the case or the investigation. And again, I didn't get an answer. I got intermittent eye contact. At which point...
I'm sorry, you asked him if he wanted to speak with you or if he didn't want to speak with you. Not that it really matters, I guess.
I asked if he would like to speak with us first, and then the second time I said is if you do not want to speak with us, at which point, Your Honor, I received the same intermittent eye contact from Mr. Perez. At which point, Wade started questioning him, going back to my indirect line of questioning about who was present at the house, specifically to the execution of that search warrant.
Why were you asking him that?
Our goal is, once we get back to the house, obviously we are underway in a criminal investigation, but also is the gain information to potentially pass on to any of the investigators at the house. Our goal is to execute these search warrants in the safest manner possible, not only for law enforcement, but for any residents, occupants, or anybody involved in the investigation as well.
Okay, so that's why you're asking him that?
Correct.
All right, so I don't mean to interrupt you. Please continue on.
Once I asked him about who was at the house, he had said that his wife was at the house. I believe I gave the name Giselle, at which I got an acknowledgement. I got a head nod. And then I asked if there's any small kids at the house. Again, which I got an acknowledgement that there were small kids at the house. So again, this kind of going back to our indirect line of questioning, right? So it is case pertinent, but not specific to the criminal activity going on. At which point, during that conversation, I went back to my direct line of questioning with Mr. Perez. And again, I received the same intermittent eye contact where Mr. Perez would look away. He would look away from me back through towards his vehicle. And at that point, it was determined that I would go and begin the systematic search of the vehicle, and I would come back to continue the interview with Mr. Perez at a later time during that traffic stop.
Okay, and did you engage him again?
Yes.
Okay, tell us about that.
So I began a systematic search of the vehicle of Mr. Perez's truck. While I was doing that, Detective Durdowski arrived on scene. I had spoke with Detective Radowski and relayed the fact that Mr. Perez was intermittently communicating with us, that he had not invoked his Miranda warning, or his Miranda rights, I'm sorry.
You said that he did not invoke?
He did not, no sir. And said that, is we're going to go back and speak with him, but is for right now we're working on the vehicle.
So when you say he didn't invoke his Miranda rights, what do you mean by that?
He never told me, that he would, wish not to speak with me regarding the investigation. It was, again, like I said, the intermittent eye contact, and then there was no mention that he wished to speak with any attorneys or anything regarding that ongoing
So
investigation.
you're looking for something explicit?
Yes, sir.
Okay. Oh, excuse me. And he intermittently answered questions with you, is that correct?
Yes, including the phone, as mentioned before, the occupants of the house, and then even his age at the time during that interview.
Okay, sorry to interrupt you again. Please tell us more, or tell us about the last interaction.
Yes. So at which point, when I was beginning my search of the vehicle, as we were going through the vehicle, I had looked back and I had seen that Detective Radowski had engaged in a conversation with Mr. Perez. So you could see via like hand movements, you could tell that they were speaking with him. So at which point I kind of ceased the search of the vehicle, and I then returned to the interview portion. And at which point, Mr. Detective Radowski and Mr. Perez were engaging in conversation, and then I stayed for the remainder of that conversation until ultimately, once that was finished, we had went back there was another detective that arrived on scene to assist in the search and completing the search of that car.
Okay, and what did you find in the car?
The only thing we found in the car was numerous money bands. So I believe there were $1,000 money bands inside of the vehicle, but no drugs were located inside the vehicle.
Okay. You indicated that Deputy Durdowski had a conversation with the defendant.
Yes, sir.
And did there come a time when you had a discussion with the deputy about what that conversation was about?
With which deputy?
Deputy Durdowski. Detective Deputy Durdowski.
So I jumped back into the conversation. I had informed him of our progress, and then I kind of jumped back in the middle of that conversation.
Okay, so all right, so you're back in the conversation.
Yes.
And tell us about that.
Yes, we were speaking specifically about the criminal investigation and Mr. Perez's involvement specifically in cocaine trafficking or drug trafficking. We were looking specifically at that time to kind of speak about backstory. We were looking for case relevant facts that pertain to kind of how he got into the position he was today. With ultimately our goal is to continue the investigation. Drug trafficking investigations are very complex and lengthy. So again, we discussed details specific to his involvement in the trafficking of cocaine.
So you're basically telling them what you know.
Yes, we were laying out the facts of the case.
All right, and please continue.
At which point, during that interview, Mr. Perez began talking about the cocaine located inside the house. I had explained to Mr. Perez as far as kind of what the next steps in this investigation were. At which point, he informed us that he was the only one involved in the trafficking of cocaine. His wife and son had nothing explicit to do with his activities. At which point, he explained to us that the cocaine was hidden in a natural void in a kitchen area of the home.
And what prompted him to tell you this?
When we were asking specifically about the amounts of cocaine that would be found inside the home, Mr. Perez explained that there was cocaine inside the home, and we had asked him about where we'd be able to locate it inside the home. We know, based on, again, my training experience, narcotics, U.S. currency can be hidden in a multitude of areas. Hidden voids in the floor. We've found hidden voids in walls, in ceilings, natural voids, like natural open air spaces in houses.
How do you find it when it's in a hidden void?
So oftentimes is a lot of training and experience. However, we've had naturally we'll use wall cameras. Sometimes is wall cameras. So basically kind of a snake camera, sir, is to see beyond. Our goal obviously is to do the least amount of property damage and be the least invasive as possible.
So in order to use, I'm sorry, I'm
Yes.
interrupting you, but in order to use a wall camera, what do you have to do?
We have to drill through the wall. Like we'll have to put like a pinhole into the wall to then insert the snake camera into the wall to see if, and what we're looking for is natural things like insulation, natural locations for 2x4s and joists, in just common areas that we've seen throughout our career.
Were you prepared to do that this day?
Yeah.
29.
Yes, we were.
Okay. How else would you search like that?
So oftentimes is what we'll do is it's a comprehensive review of whether it be a room. First off, we would identify, again, natural voids first, just because creating a trap location or a hidden location is oftentimes extensive. So natural voids in residential construction is our first look. We'll also utilize tools, as I said, like a snake camera that can be utilized through a wall. We'll utilize canines. Not only...
Well, tell me about canines. How do you use a canine for that?
Yeah, so two ways. First off, the most common view of a canine would be is if a canine alerts positively to one specific location. Oftentimes that could be behind a wall, that could be an elevated position, that could be in floorboards. Also, too, though, is what we will utilize, because there's common methods and tactics that are used to conceal odors, is we'll also often put not only the canine into the room for narcotics detection, but we also have access to what we call a U.S. currency dog.
The U.S. currency dog, can you tell us about that?
Yes. The Cleveland Police Department, specifically Patrolman Paul from Cowick, is a canine handler for the Cleveland Police Department, often attached to the U.S. Customs Agency as a task force officer. His canine is certified in the detection of U.S. currency, not specifically drugs or narcotics. We've used him previously on multiple investigations, including drug trafficking, large-scale like interstate drug trafficking, and money laundering investigations successfully.
Did you have him on standby for this investigation?
Yes, that was the next call.
All right, so you had other alternatives of what was going to occur if he didn't tell you where it was.
Correct. We had a systematic approach. Is once we figured out what the evidence that we located on scene following the interview, is we would then go through our systematic approach through narcotics detection dogs and ultimately to a U.S. currency dog if necessary.
Is that sometimes using those methods, could that be sometimes destructive?
Yes, sir, absolutely. Which is oftentimes why we want to lay out the facts of the case to the subject we're dealing with. Our goal is not to commit property damage. However, based on the search warrant, we are there to look for evidence pertaining to our ongoing investigation, including very well hidden locations.
And Detective Derdowski explained that to the defendant, is that correct?
Yes.
That we could have to do this.
Yes.
And when he says that wasn't a threat, was it?
No, that was simply us laying the facts of the case out so that whoever we may be dealing with, in this case, Mr. Perez, could make the best decision with the facts at hand. So that was going to be happening if necessary.
So that's when he told you, hey, this is where it's hidden?
Right about that time, yes.
Okay. Were you present when the cocaine was found behind the board?
No, I was not.
Who was there for that?
Those were, I believe, representatives from the Lake County Narcotics Agency. I was still roadside with Mr. Perez, Detective Derdowski.
And did the defendant tell you anything else?
Did you go to the scene eventually?
Eventually, yes, sir.
They were still conducting the search when we got there?
Correct. They were still conducting the thorough search of the house, yes.
That was your plan, to go to the house and assist with the search after you were done at this
Yes, sir.
stop?
Yes, sir.
Because you were going to return to the house with the defendant, is that correct?
Yes, sir.
Okay.
Let me ask one other question.
Yeah, sure.
When the defendant disclosed where the drugs were you there at that time?
I was, so not at the initial, I don't believe at the initial point. I walked in through the conversation, a little bit into that. So then we started
When
going.
you said you saw them talking, when you saw them talking, you went there. I didn't know what.
Yes, I believe that investigation, or that conversation had commenced prior to me getting back. But we kind of went back over the details during that conversation as far as where it could be located.
Go ahead, Mr. Gary.
Thank you. At any time, did the defendant tell you that he was going to invoke his right to remain silent?
No,
Did any time he invoke his right to have a lawyer present?
no.
So just to clarify, you had Deputy Hop was present there
Yes.
with his dog.
Yes.
You had K-9 Dalton was present, correct?
Yes.
And you had the currency dog on standby
Yes.
from the Cleveland Police Department.
Correct.
Thank you, nothing further.
Cross-examination.
Your Honor.
Morning, still morning. Good morning, Detective.
Good morning, sir.
How are you?
Good. How are you?
Attorney Brad Wolf, a few questions. If I talk too fast or confusingly, just let me know.
No problem, sir.
Thank you. Detective, you just testified that drug investigations are complex and lengthy.
Yes, often.
Fair to say this investigation was complex and lengthy?
Yes.
Your investigation began in about March of 2024?
Approximately, yes.
Okay. And it involved Jose Perez as a suspect, correct?
Yes.
And also another individual named Trey Jones.
Yes, sir.
Trey is not charged with any criminal offenses in this jurisdiction, correct?
Correct, sir.
But he is charged with various drug trafficking and related offenses in Geauga County.
Yes, sir.
Now, as part of your investigation, there were trash pulls conducted of
Yes.
Jose's residence.
Yes.
I believe 9 to be exact.
I believe so. I believe so, without having the actual in front of me, but yes, I believe so.
Okay. There was GPS tracking involved,
Yes, sir.
meaning that your agency applied for and received a GPS tracker warrant.
Yes.
Okay, and that was then placed on Jose's vehicle for a period of time.
Yes, sir.
Okay. You used all this information then to produce an affidavit, correct?
Yes, sir.
14-page affidavit?
Again, I'll take your word at that, but
Does
yes,
that
without
sound
having
fair?
it in front of me, yes.
Fair enough. Okay. And then on May 29th, as we've discussed, your agency and the Lake County Narcotics Agency and the Lake County Sheriff's Office conducted a joint search of Jose's person, vehicle, and home.
Yes.
And you prepared a report in this case?
Yes.
Okay. I'm not going to show it to you, but do you have any changes to make to your report from the time when you made it?
No.
Okay. To the best of your ability, it was an accurate and honest report when you made it?
Yes.
Fair enough. Now, you indicated that the stop of Jose's vehicle was done, testified that, so that the stop was done to separate him from his residence, correct?
Correct.
Okay. That he wasn't stopped for any traffic violation?
No, with the active warrant to seize his person, the vehicle, and ultimately the home.
Got it. And we'll talk about the warrant. You did testify, though, that you believe the warrant was signed in the morning?
I was not the affiant on that warrant. I believe it was prior to the operation. So it was signed prior to establishing this operation.
And I'm just asking about what you just testified to, because you testified to that it was signed in the morning.
I believe it was the morning, yes.
Okay.
Like prior to the operation.
On May 29th?
Yes.
Okay. That's not listed anywhere in your report that the warrant was signed in the morning, fair?
The warrant was signed out of county, so no. It was just the warrant was executed.
Got it. Okay. And the reason we're talking about this warrant is very important is, do you recall that in your report, just yes or no, that you used the word impending to describe the status of the warrant?
Yes.
When you stopped? Okay, fair. And
Oh.
Did I hear correctly that you just testified? Did you have the physical warrant during the stop?
Like the actual signed copy of the
Yes.
warrant? No, I did not have it with me at the time of the stop. But the use of the word impending, though, I just mind.
Hang on.
Sorry.
Well-
Just answer the question. That's not a question. Go
Yes,
ahead,
sir.
Mr. Wolf.
Thank you, Judge. Who had the physical warrant?
I believe it was Detective Ultimus.
Okay, so somebody at the house.
Yes.
So we can agree nobody on scene had a physical warrant.
I don't believe so.
Fair enough.
Just to clarify, Your Honor, when he's talking about scene, there's two different places.
You're talking about the stop, right?
The traffic stop.
I understand.
I'm just,
Go ahead and answer your question.
thank you.
Thank you. Okay. Now, I'm just referencing your report, and by all means, I can hand it to you if you'd like to refresh your memory, but
Yes, sir.
am I correct that because the warrant was impending, an open-air canine sniff was done in this case? Is that sentence accurate, what you put in your report?
No.
Okay. Your Honor, I'm going to hand the witness what's marked as Exhibit A. This is the report, and I just want to
Judge.
look at.
This is his report? Is that what you-
Yes, Your Honor.
Okay.
Thanks, sir.
And take your time, if you could let me know if that's an accurate copy of the report you prepared in this case.
Yes, it appears to be, sir.
Okay. And then I took the liberty to take a blue pen mark and just to highlight on page, so what's bait stamped is LCPA 132. It's the fourth full paragraph down.
Yes.
And I just want to know, due to the impending search warrant on Perez's residence and vehicle, LCSO, Deputy Hop, and K-9 Sato were requested to conduct an open-air sniff of the Chevy Silverado truck. That's in your report, correct?
Yes.
Okay. Detective, I'm not going to do a lot of this, but would you dispute me if I said that dictionary.com defines the word impending as about to happen?
No.
If the warrant wasn't impending, your words, would the canine sniff still have occurred?
Yes.
Okay. And one of the reasons we do a canine sniff is to search for contraband like drugs.
Yes.
You had testified that the canine located or made a hit and it was on for money bands, correct?
The canine made a hit to the driver's door of the vehicle.
Okay.
Ultimately, the money bins were found, but the canine did alert to the trained narcotic odor at the driver's door of the vehicle.
Okay. No drug, fair to say no drugs were located in the vehicle.
Yes, sir.
And again, what was found was numerous $1,000 money bands.
Yes, sir.
Okay. After, sorry. You testified that you are the detective who gave Jose his Miranda rights, correct?
Yes, sir.
Fair to say you've received training on how to administer Miranda?
Yes, I've given it prior many times before.
I assume so. You confirmed with Jose that he understood his rights, correct?
Yes.
Okay. Now, isn't it a fact, though, that Jose said 3 separate times he did not want to speak with you?
No.
Okay. Nick.
What is that? Yeah.
Now,
Oh, I get, this is mine?
Yeah.
Oh, cool.
now, Detective, I'm going to come back to that very crucial point in a moment.
Yes.
There were 3 audio recordings created in this case, correct?
Yes, sir.
And they were all created by way of a recording device that you were wearing?
Yes.
Okay.
Not wearing just a physical recording device.
So you hold it in your hand?
Yep.
Got it. You had activated it when you read Jose his Miranda rights?
Yes, just prior to the initial approach from
Got
Mr.
it.
Perez.
Got it. And on this first recording, Your Honor, I'm approaching the witness with what's marked as Exhibit J. And this is a transcript of
Yes.
the recording. I have used the website of rev.com, rev.com, to translate or transcribe the recordings in this case, Judge, and I've given a copy to the prosecutor. I would just ask the witness, just take a moment and just review this, and to the best of your knowledge, please tell me if this is accurate.
In the spirit of that interview, yes, but I mean, there's multiple, just little transcriptions that were not my words.
Okay, and if those become relevant, please just tell me.
Okay.
The paragraph I want to focus on is on the first page, and it's the longest paragraph. Unfortunately,
Is
there's...
this an exhibit? I'm sorry, you missed.
Yes, Your Honor, this
What
is
letter?
Defendant's Exhibit J.
Thank you.
Just tell me if I'm reading this correctly. So where we're going with this is, we want to sit down with you, have a conversation with you about where this is at. Do you wish to talk to us at all? You don't want to talk to us at all? Nothing at all. Okay. And then it goes on. Did I read that correctly?
Those are my words, yes.
Okay, thank you. And it's still your testimony that Jose didn't advise he wanted to speak with you?
No, nothing verbally.
You'd agree that when you were trained on Miranda, did you learn that if a suspect invokes their right, all questioning must cease?
Yes.
Okay. And is it your testimony that you believe the suspect must verbally invoke that right?
Verbally or acknowledge, but as I said, the
Verbally or what?
verbally or like as a head nod or an agreement, like within the spirit of that conversation,
Okay.
like an overt action.
Okay, so when you testified earlier that you said he looked away, there was intermittent eye contact, correct?
Yes.
Okay. And then you repeated the question 2 more times, correct?
Yes.
Okay. So we can agree though that he never that he never affirmatively said, "I want to talk to you."
No, but there was
So
no.
You can't agree to that, or?
I'm sorry, repeat the question one more time. I apologize, Judge. Your question threw me off.
Can we agree Jose never affirmatively said he wanted to talk to you?
Never those words specifically. He never said, yes, I wish to talk with you.
Just to wrap this up, what he did do is he looked away, your testimony,
Yeah.
and you asked him the same question 2 more times.
Yes.
I want to talk about your audio device. As far as you're aware, and forgive me if I just asked this, but there was a total of 3 detectives on scene for the traffic stop? 2 from your agency, 1 from Lake County?
The Lake County deputy, not a detective, a road patrol deputy, specifically the K-9 unit.
Forgive me, okay. Of the 3 of you, you were the only one with a recording device, correct?
Ultimately, yes.
Okay. The recordings in this case, from the time you created them, have they been altered at all? Okay, so you
No.
didn't go back and shorten or change anything?
Absolutely not.
Okay. I want to reference your report again,
Yes.
Detective. And it's in the spirit of whether you believe Jose invoked his Miranda.
Yes.
But now I want to look at the 3rd paragraph on, again, date stamp 132.
Yes, sir.
And just tell me if I'm reading this, just yes or no, am I reading this correctly? Initially, Perez informed detectives that he did not wish to speak with them and denied any knowledge or participation in any type of drug trafficking.
So what are you reading there, sorry?
Sorry, Your Honor. This is from Defendant's Exhibit A, page 5 of,
Which is his report.
yes, Detective
Yes, sir.
Report. And I'll repeat. So just this is the start of paragraph 3. Initially, Perez informed detectives that he did not wish to speak with them and denied any knowledge or participation in any type of drug trafficking. That's from your report, correct?
Yes.
Okay. Now, there comes another time in the recording. No, Your Honor. In my opinion, there's a fourth time when Jose clearly invokes he doesn't want to talk. And what I'm referring to is after the first three questions we just went over, there's a fourth question. And this is at the bottom of the large paragraph, sort of in the middle bottom of the page.
Is this the Exhibit J,
This is
sir?
Exhibit J, thank
Okay.
you. And the question you ask is, so you don't want to talk to us at all? And then you say, perfect. Do you recall asking him that question? That
Yeah.
day?
Yes, my words.
So 4 questions from you, just logically, math here. There was 4 questions from you about whether he wanted to talk.
Yes.
Okay. Now, you testified after he was Mirandized that you then proceeded with an indirect line of questioning?
Yes.
Okay. And I presume when you're referring to his wife's name, his kid's name, correct?
Yeah, the presence of like the phones in the car, not
Got it.
anything specifically to drug trafficking.
Well,
And that's why I said indirect. It's not
Yeah.
It's not unimportant, but just indirect.
being fair here, though, you did ask if there was any drugs on him, correct?
At some point in the interview, yes. I don't know if that was.
Well, specifically,
Where are you referencing, sir?
well, I'm just asking you, do you recall then saying, is there anything inside the car, Jose? Nothing at all, not even a little bit, no heroin or meth, marijuana, no coke?
Yes.
Okay. And is that still within the indirect line of questioning you referenced?
Yes, it would be.
Okay. But that's about drugs, correct?
Correct.
And during the indirect questioning, just to be clear, he's still detained, correct?
Yes.
He's still in the back of the marked police car.
He was either in the initial part of that interview, I believe, was outside of the police, like just next to the police car.
Okay.
So at this point in the interview, I'm not sure if he was sitting in the back of the cruiser or directly adjacent to it.
Okay, okay. Prior to your testimony, we've been discussing the timeline in this case, and as the creator of the audio files, I just want to ask you, of the 3 recordings, would it make sense if I told you that the first recording is 5 minutes and 19 seconds in length?
If that's what the file says, yes. I don't have the physical property in front of me.
Your
If someone
Honor,
has a phone, they need to leave. All phones need to be turned off, not silenced or turned off.
They were going, sir. Ma'am, hang on, it's locked.
Please continue.
Your Honor, I'm approaching the witness with what is marked as Defendant's Exhibit G and Defendant's Exhibit H.
Good.
And, Your Honor, Detective, these are screenshots that my office has taken the liberty to capture. I submit to the court that when opening the basic property files of these recordings, and actually, Your Honor, would you like to see a copy of these?
Sure.
So I submit to the court, Your Honor, that when opening up the files as shared by the prosecutor, this is what you see. And Detective, I just want to ask you about these pictures. I'm also happy to pull up the original files on my computer as well, just to qualify these exhibits a little bit, Your Honor. In any event, looking at Exhibit G, Detective,
Yes.
where it says Jose Perez Miranda 1-3 properties, would you agree it says length 5 minutes and 19 seconds?
Yes, that's what it shows in the paper, yes.
Okay. Do you have any information to dispute the accuracy of both these exhibits?
I have no information to dispute them.
Okay. Would you agree with me that on Defendant's Exhibit G, the media was created at 3:58 p.m. according to this document?
According to the timestamp in this document, yes.
Okay. And then logically, if it's about 5 minutes long, it would have ended at 4:03 p.m. approximately.
Approximately.
Okay. Now, after the first recording ends, you'd agree with me that there was a period of time before the second recording starts.
Yes.
Okay. And of course, I'm referencing Defendant's Exhibit H, and this is Jose Perez interview 2-3 properties. And do you agree with me that this says it was created on 5/29/24 at 4:25 p.m.?
Yes, that's what it says.
So the first recording ends approximately at 4:03. The second recording starts approximately at 4:25. We can agree it's approximately 22 minutes gap.
Yes.
Okay, thank you. And I believe I asked you, but you're not aware of any other audio or recordings which existed at all, but especially during this gap?
Correct.
Okay. You'd agree with me, there's no physical documentation where Jose consented to waiving his Miranda rights at any point? Physical documentation.
Could you define physical documentation, though?
There's no paperwork that Jose signed that you're aware of that said he understood his Miranda rights and that he's waiving them.
No, there was no
combination of the.
There was no physical paperwork. No.
Okay. And he was still detained for this 22-minute gap, correct? This was still on roadside?
Yes, we were still roadside.
All right. I just want to ask you about the gap, and specifically, are you aware that your department, Geauga County Sheriff's Office, has a specific policy that outlines the use of portable audio and video recorders?
Yes.
If I showed you a copy of this, could you tell me if you recognize it?
Yes, sir.
Okay. Your Honor, I'm approaching the witness with a copy of Defendant's Exhibit E. Let me know after you've had a chance to review it, please.
Yes, I'm familiar.
Okay. Have you seen this policy before I've just given it to you?
Yes.
Okay. Does this policy appear to be accurate from when you last saw it?
Yes.
Okay. And this policy was in effect on May 29th, 2024, correct?
Yes.
Okay. So on page 2 of this policy, are you aware that it states, when using a portable recorder, the assigned member shall record his or her name, GCSO identification number, and the current date and time at the beginning and the end of the shift or other period of use, regardless of whether any activity was recorded?
Yes.
Okay. That didn't happen in this case, correct?
Not the time, but the suffice to this would be me identifying myself to Mr. Perez of who I was,
Okay.
and then utilizing his first name to identify who the subject of the interview was.
Fair enough. And then also on page 2, item 421.6,
Yes.
which is titled Activation of the Audio Video Recorder.
Yes.
Do you agree, are you aware that it says the policy is not intended to describe every possible situation in which the portable recorder should be used. Although there are many situations where it's appropriate, members should activate the recorder at any time, believing to be appropriate, and then specifically looking to subsection A and B. The portable recorder should be activated during all enforcement and investigative contacts, including stops and field interview situations. That's A. And then B says traffic stops, including but not limited to traffic violations, stranded motorist assistance, and all crime interdiction stops.
Yes.
Are you aware of that? Okay. So, and then last one, item 421.6. titled Cessation of Recording. Are you aware, prior to the investigation in this case, that once activated, the portable recorder should remain on continuously until the member reasonably believes that his or her direct participation in the incident is complete, or the situation no longer fits the criteria for activation? Recording may be stopped during significant periods of inactivity, such as report writing or other breaks in direct participation in the incident. Did I read that correctly?
Yes, you read it correctly.
Okay. Now, I believe Jose indicated 4 separate times that, he didn't want to talk before turning off the recording. But I guess my question is, you intentionally, you meant to turn it off
Yes.
during that 22-minute gap. Okay. And you would agree that recording 2 starts with the other detective on scene, whose name I'm blanking on, but he just testified. And do you recall walking up to him as he's having an interaction with Jose,
Yes.
and you turned your recorder on?
Yes.
Okay. We don't know how long that detective was talking with Jose, though, do we?
I don't know. I could approximate by the time I visually saw it and then joined into the conversation.
Okay. I mean, we're just guessing. We don't know if he was talking to him for the entire 22 minutes. Do we know?
I do not know, sir.
Okay. So we don't know what that detective and Jose spoke about with regards to Jose potentially waiving any Miranda rights.
I can't say what was said between them before I arrived.
And when that detective was speaking with Jose, that's eventually when Jose disclosed where the cocaine was located, correct?
Yes.
And prior to that disclosure, Jose had not said where any contraband was located in the house, correct?
Correct.
Okay. And are you aware, if you were, well, you were there for this because it was recorded. Do you recall when the other detective said, in sum, do I just need to send a team of guys there to start ripping through the house? Do you remember the other detective saying that?
I don't know if those are the exact words, but we were discussing our tactics that would be utilized. Yes.
Okay. Moment, Your Honor. Transcript number 2. Your Honor, I'm approaching the witness with Defendant's Exhibit K.
Okay, okay.
Perfect. Thank you.
But, Your Honor, this is the second of 3 transcriptions that we prepared of the audio recording. Detective, just, I know it's 19 pages, but take your time. I just want to know if it looked relatively accurate.
Who's this of?
This is Detective Humar's recording that he made.
Oh, okay.
Yeah.
This is the one that started at 4:25.
Yes, Your Honor.
Okay.
And I'd like to point your attention to page 2. First full paragraph, but it starts with the next stage.
Yes, I see what you're referencing.
And am I correct in reading that the very last line of that paragraph is, do I just need to send a team of guys there to start ripping through the house? Correct?
Yes.
Okay. And then Jose said no. Got it. And then it was shortly thereafter where Jose disclosed the cocaine was in the cupboard, correct?
Yes, it does say the cupboard. I believe that was the first mention, but I'd have to go back to the audio.
Okay, fair enough. And then he goes on to provide you and the other detective with a number of steps that need to happen to access the cocaine, correct?
Yes, 2 steps.
Well, can we agree he gives you a lot of information on how to remove the cupboard?
Yes, but we were relaying the information, so we were trying to orient people who were there without knowing the physical location, so yes.
Yeah, I think we can totally agree on that. Now, revisiting the first recording that you made,
Yes.
do you recall saying to Jose that, quote, if the house is empty and there's nothing in the house, cool, you'll be on your way, end quote?
Yes.
Okay. And it's fair to say that you had not located the drugs before Jose disclosed, excuse me, strike that. The drugs were not located by anybody involved with this investigation until Jose said where they were.
The bulk drugs were not located. I don't, like I said, I wasn't part of the inventory at the house.
Sure.
But the bulk drugs that we're referencing, the cupboard drugs,
In the kitchen.
were not located yet.
Fair enough. And then there's a third recording in this case. And there's a point where you specifically ask Jose if there's any more drugs in the house. Do you recall that question?
I believe so, yes.
Okay. And specifically, just tell me if this is fact, you said, is there any more coke here? And Jose answered, whatever you found, man, whatever you found. Does that sound accurate?
It sounds accurate, yes, sir.
Okay. And then you say, that's not a super comforting answer. Do you remember saying that?
Yes.
Okay. And Jose says, what I gave you. Does that sound accurate?
Yes.
Okay. And then the last thing I just want to say on this point is, do you recall saying, after Jose says what I gave you, I know, that's what I'm saying. It's kind of a default, but again, you have a beautiful outfit, dude. I'm not trying to. I don't want to rip it apart. I really don't. End quote. Do you recall saying that?
Yes.
Okay. So, it's fair to say that Jose's answer of whatever you found, would you agree with me? He's not really confirming or denying if there's any more.
With those responses, correct.
Okay. So there could have been more drugs.
Potentially.
Okay. And after he gave you that non-answer, did you search any more throughout the house for drugs?
There was teams still searching at that point.
Okay. After he gave you that non-answer, were any other walls ripped up at all?
I'm not sure, specifically with the time frame of, because there was a team working inside the house, still searching the house.
Okay.
When we were speaking with Mr. Perez, I believe it was inside the garage of the home.
Mm-hmm. So, just so I'm clear, do you know for certain if any wall was ripped up at any point during the investigation?
The kitchen walls and...
Sure, and I can rephrase that. Other than the kitchen cupboard, were any physical walls in the home ripped up, to use your words?
I'm not sure.
You're not sure?
I do not know in terms of how the length of the search went because I wasn't involved in the beginning of the search.
Okay. But you've reviewed the materials in this case since then, right?
Yes.
Okay. And in your review of everything in this case, is there anything to suggest that any wall was actually ripped up in this house?
Not in the case report, no.
Okay. No further questions, Judge.
Redirect examination.
Thank you, Your Honor. So, in your report, you indicated impending war. You recall that?
Yes, sir.
And you were requesting Sato, the K-9, be there.
Yes.
Okay. So is that requesting the officer and the K-9 be available?
Yes.
Okay. So the warrant is not impending, the execution is impending.
The physical search is what was impending, not only for the vehicle, but then obviously, like I said, we're in the infancy of the search at the house.
And ripping through the house. If he didn't tell you where it was, what would have happened?
Is we would have systematically went through the house, again, beginning with natural voids, utilizing the walls, ceilings, floors, underneath staircases. Again, And then if nothing was found from that point, again, specifically to our case, when we go through this process, at the end of the search, depending on the evidence found, along with any statements made on scene, is we kind of come together in a culmination of the totality of the circumstances on whether or not we believe there's potentially more drugs hidden at that time.
So, do you still have Defendant's Exhibit J before you?
Yes.
Okay. Now, you see the format of, and this is the Defendant's Exhibit, correct?
Yes.
All right, it was created by Rev.com. So we're going to view this in a light most favorable to the defendant, okay? I want you to look at the paragraph on the first page where it says Detective Umar. The big, long paragraph.
Yes.
Okay, that's you talking, correct?
Yes, those are my words.
Now, on the column on the left, you see the column furthest to the left where it has names. Do you see that?
Yes, sir.
Okay. Whose names are there?
Myself and Jose Perez.
And so, do you recall this conversation at all?
Yes.
Okay. So, when they have Detective Umar, colon, and it says, "What's up, dude?" Do you see that?
Yes, the very first sentence.
Okay, so that indicates who said what, right?
Yes.
All right, so I'm calling your attention to that big, long paragraph in the middle that the defense just made numerous assumptions about, correct?
Yes.
Is there anywhere in between that paragraph where it says Jose Perez?
No.
So does Jose Perez say, yes, I don't want to talk to you? Because that would be here, I would assume.
Yes.
So he never says, I don't want to talk to you.
No, sir.
Thank you, nothing further.
Recross-examination.
Your Honor, may I have a moment?
Sure.
Just several questions, Your Honor. Not much.
That's fine.
Detective, prosecutor just asked if what would have happened if Jose didn't disclose where the cocaine was.
Yes.
Correct? Okay. But if we're being fair, you don't know for certain if the drugs would have been disclosed or found, rather.
Can you repeat the question?
You don't know. You can't say today with absolute certainty that the drugs would have been located.
We would have conducted our extensive, thorough search and then made the determination at that point.
I appreciate your answer, but for the purposes of the record, you can't say with any certainty that the drugs would have been located.
Objection asked and answered.
Overruled. Overruled. Answer the question.
Correct.
And are you also aware that the search had been happening for a period of time before Jose made this disclosure?
I knew the house was locked down and the search had commenced. I didn't know at what point or in the search that, like, as far as it had progressed.
Would you be surprised to learn that we had prior testimony today from Lake County Narcotics Agent, Special Agent 91, that the search was actually at the midway point when they had learned this information about the cupboard? Would that be surprising to you?
Again, I have no reference. I wasn't at the house.
One additional moment, Your Honor.
Excuse me.
Yeah. Nothing further, Judge. Thank you.
All right, you may step down.
Thank you,
sir.
Your Honor. Would you like these exhibits, sir, or just leave them?
Leave them right there. Thank you. Statement called to next witness.
The state of Ohio would arrest, Your Honor.
And the only exhibit you had was number 1.
That would be correct, Your Honor.
Huh? What was number 1 again?
That was the judgment entry.
Oh, we need that.
I don't have it. Oh, hold on, before I'm a liar. We rested, assuming.
Any objection to exhibit 1?
No, Your Honor.
All right, that be admitted. All right, Mr. Vincent intend on presenting any testimony?
Nothing additional, Your Honor.
So in regards to your exhibits, what are you moving for the admission of here? I'll go through what I have as identified.
Okay.
Umar report is A, I'm not admitting that, I don't know if you're moving for it, if you want to.
I'm sorry, Judge, I didn't hear you.
First, Exhibit A was Detective Umar's report. I'm not going to admit that, but if you want to, for the record, move for its admission.
Yeah, I'd ask for its admission, Judge.
That's denied.
Did you want me to object to that or no?
I'm not allowing it, I can do whatever you.
No, I didn't know if you
That's all
wanted.
right.
Okay,
If I need a response from you, I guess I'll ask for that.
all right, cool.
B, I don't have identified.
Correct.
I missed it. C was the search warrant, any objection to that?
No, Your Honor.
C will be admitted. I don't have a D.
Correct.
E was a jog of policy on something.
421, I'd ask for that to be admitted. That was the recording procedures.
Any objection?
No, Your Honor.
All right. E, it was E, right? E as in Edward?
Correct.
Yeah, it'll be admitted. There is no B. You have a B? What do you have?
I don't think that was supposed to be. Yeah, we never discussed that.
Or then take it back.
I think that he used that for identification.
We did in the very beginning.
So is that an LCNA report?
Yes, for the record, I'd ask for it to be
All
included.
right, that's not being admitted. All right, so we are on F for the LCNA policy regarding Miranda interrogation.
Yes,
Correct.
Judge, I'd ask for that to be admitted.
Any objection?
No problem, Your Honor.
F will be admitted. G and H are the screenshots that were just discussed.
I would ask for those to be admitted, Your Honor.
Any objection?
No, Your Honor.
I'll allow G and H, I'll admit those. I do not have as being identified.
Correct.
J is the first transcript of the recording. I think this is the, well, J and K are transcripts of the recordings.
And I would ask for those to be admitted.
Any I'm not allowing those. First of all, K was only used to refresh his memory as to one portion of, I think, about the ripping of the walls. You had him look at that to say, did I read that right or something like that. That was the only, I'm not admitting those. And if there's recordings, you can put those in, but those are not being admitted. L, but I don't have an L. M through P were photos of the kitchen. I'm going to admit those. I'm assuming you removed for the admission of those, right? I'm assuming you wanted those.
Yes, Your Honor.
They do not have a Q, R, or S. That's correct?
Q was one of the pictures, Judge.
Oh, that was a picture too? All right, I'm sorry. All right, and Q is admitted. I do not have an RS. T is inventory of the house, and U and V is the other inventories involving the phones. I think that was just shown to, U and V was just shown to, because he said, I'm not sure if there's other inventories or something like that.
I guess for the record, I'd ask for them to be included. They help the detective identify the cocaine, but
Any objection to those?
No.
All right, I'll admit T, U, and V. All right, thank you.
in response to the transcripts not being entered, Your Honor, I have all 3 original audio recordings on a jump drive. I've showed this to the prosecutor. I would just ask or proffer that this be admitted as its own exhibit of the audio recordings that were referenced many times today.
Any objection to that?
Just as a procedural thing, Judge, he rested and now he wants to add evidence. He could have put them in. He could have played them. I mean, I really don't care if the court thinks it'd be helpful. Yeah, I wouldn't have an objection.
Do you object to the transcripts in terms of any type of, you're not questioning those at all, are you?
As for,
Did you compare the transcripts to the original video? I mean, is there any?
I got these yesterday, Your Honor, so no. And it isn't like it came from a court reporter or anything else.
I'll allow J and K for what they're worth.
Okay.
Thanks, Judge.
All right, I hear closing comments from the state.
Your Honor, if I may, respectfully request to file a post-hearing brief. This is a very significant case.
I'm going to hear closing arguments from, I've already got that motion from you. I want to hear closing comments. and then
Okay.
I'll decide how we're gonna go from there.
Thank you, Your Honor.
This is a case. It's no more significant than any other case, all right? This case is like every other case we have here.
Just, Your Honor, for the record, it's a mandatory drug offender specification case, and I think a lot of information was learned today.
And
And
I
very
want to
respectfully-
hear closing arguments. Mr. Bagridge,
Go ahead.
yes.
Thank you, Your Honor. As outlined in the brief, there was a warrant for the defendant's person and the vehicle, so there was probable cause. It was found by Judge O'Donnell for that stop. I think the first cause of action is frivolous almost. Secondly,
First cause of action doesn't deal with there being a search warrant or that sufficiency of that. The first issue deals with the stop of the car
the stop of the car,
and
yes.
whether there was a search warrant that had been issued at the time of that. And then if not, you guys argued that they could have a right to stop the car anyway.
Right, the warrant was in force. They had the right to stop it. It was found, there was probable cause to stop the car. It was found by Judge O'Donnell that we could seize the car.
Now, he's not challenging the probable cause of the issuance of the warrant or anything.
No, he's saying that we had no probable cause to stop the car, period.
Because he's saying there was no warrant at that time.
Exactly.
Well, that's what the issue is then.
Well-
The issue is, he's claiming that the issue of the warrant was impending at the time, so it hadn't been issued yet. And since it hadn't been issued yet, there was no authority to stop the car, and there was no other probable cause to stop the car. There was no traffic violation or any other offense that was observed. So that's the issue here.
All right, my point, or in the testimony, Your Honor, is that that warrant was already issued, and they had probable cause to stop the car.
Based on
You've
the
heard
issuance of the
testimony
warrant.
from everybody to that,
All
every
right.
witness.
Okay.
Secondly, as for his right to suppress his statements that he made to the police, I don't think that he made an overt or explicit intention of his right to remain silent. You heard that he looked away or these type of things, but he also answered questions.
Let me interrupt you for a minute, because your
Sure.
brief that you filed, the last paragraph before the conclusion, the first sentence says, "Applying the law to the facts of this case, the state's expected testimony will prove that the defendant was advised of his constitutional rights during the traffic stop and then invoked his right to remain silent." That's your first sentence of that paragraph.
He was advised of his rights.
And then invoked his right to remain silent is the last part of that sentence. That's your brief that you filed.
Uh-oh.
Your brief says that the defendant invoked his right to remain silent.
I think by speaking,
I'm just saying, you
I
are arguing
understand
that he
that.
didn't
I do
invoke his
understand.
right to remain silent, and your brief says he did. So I don't know what the position
I don't
is.
think that the evidence shows that we presented here today. I think he made his statement, he did make his statement in response to the fact that, this is what's gonna happen to the house. And that wasn't an idle threat, it wasn't a coercive thing, it was a fact that was gonna happen, and he decided to tell the police to save up the house. Even if you found that the statement was involuntary or whatever, it would be an inevitable discovery due to the fact that you had two canines that were present. They would have gone through, you have testimony from the detectives that they would have gone into more invasive measures, using the cameras, using both of the two dogs that were present, plus the currency dog that was on standby. So it would have been inevitably discovered, because you're hearing it's right behind a wood faceplate on a cupboard. The dog would find that. We see that with the cars. You heard the testimony that they find it in walls, but behind drywall even, and they would have torn it out. So I'm arguing that even if you find that his statements were involuntary, that it would have been an inevitable discovery due to the execution of a valid warrant by the police there with the dogs, with with being able to drill into the walls and things of that nature. And that's where they were prepared to go. And when the detectives told the defendant that, they meant it. And it wasn't a threat, wasn't an idle threat, that's what was going to happen. So regardless of whether he tells them or not, they are going to find it, Your Honor. So we'd ask that this motion be dismissed. Thank you, or not dismissed, overruled.
And Mr. Wolf,
Thank you, Your Honor. If it pleases the court, may I stand at the podium?
you do it.
Yeah, I have quite a bit of comments.
No worries.
Just one moment, Your Honor. Thank you, Judge. May it please the court. Your Honor, this is a case where the police would not have found the contraband at issue, but for violating Mr. Perez's rights. The evidence gathered here, including the drugs, the money, and the statements made by Mr. Perez, are fruits of the poisonous tree from law enforcement's violations of his constitutional rights. The law, Your Honor, allows for officers to make investigative traffic stops if they have reasonable suspicion that the person is engaged in criminal activity. On May 29, 2024, officers began their interaction with Mr. Perez by surveilling him at his workplace of Chem Technologies. As the state explained, officers had been investigating Mr. Perez for around 2 months prior to May 29th, time in which they uncovered enough information about Mr. Perez to later obtain a search warrant for his vehicle, residence, and person. On May 29th, 2024, officers observed Mr. Perez at his work prior to commencing the search warrant. During this time, we heard today that there was no observation of him engaging in any illegal activity at all. Officers then watched him leave work, enter into the public roadway. They did not observe any traffic stop, and then they did effectuate a stop which has been deemed for officer safety. Your Honor, I respectfully submit that the officers did not have reasonable suspicion that Mr. Perez was engaged in any criminal activity to justify their traffic stop.
Would you agree if there was a search warrant for the search of that car, they had a right to stop the car?
If the search warrant was active and not impending, then I would agree, Judge. But respectfully, Detective Humar himself described the warrant 2 separate times in his report, which he said was accurate, as impending. And he also agreed, or didn't dispute the definition that impending means about to happen.
Yeah, the search of the execution of the warrant is about to happen.
I fully acknowledge detective testified to the word execution. He said the execution was impending. My position, Your Honor, is that the report says, the report omits the word execution. It just says the search warrant was impending. And then detective goes on to say that because of the warrant's impending status, that a canine dog was requested to perform the open air sniff of Mr. Perez's vehicle. That did not yield any contraband. So, Your Honor, I think I've made the record clear in my position that I believe the warrant was impending. Moving on to Mr. Perez's Miranda rights being violated. Respectfully, even if this court finds that there was suspicion, reasonable suspicion, to stop Mr. Perez, I submit the statements were obtained from Mr. Perez in violation of his Fifth Amendment right. It's well established, Your Honor, that officers must give Miranda warnings to individuals who are in custody. While in the back of the police cruiser, and he was explicitly told he was detained, he was given Miranda. No one's disputing that. Miranda requires that once an individual invokes their right to remain silent, the interrogation must cease. I'm citing State versus Jenkins, which is an 11th District case from 2003. It's 2003 L173. And today we heard that Mr. Perez made it clear, by my count, 4 times with Detective Humar that he did not wish to speak after being read his Miranda rights.
And you're basing, when you said your count, you're basing that on those the transcript where he made the comments. I can't remember exactly what was said. That's what you're basing when you say 4 times, right? In the transcript,
just so I understand, based on the, sorry, Judge. No, just based on the line of questioning and that Detective Humar engaged with.
That was reflected in those transcripts?
Yes, Your Honor.
Okay, that's what, we're on the same page now.
And Detective Humar indicated himself, testified himself, that Jose did not affirmatively seek to talk. It meant he did the opposite. He looked away, had indirect eye contact, to the point where he did not. Detective Humar asked him 3 additional times if he wanted to talk. Logically, Your Honor, I would submit that the inverse of that is that he stated he indicated he didn't want to talk. And there should not have been any more questioning. We've heard testimony today that Mr. Perez initiated conversation himself. We've also heard conflicting information from Detective Humar's testimony that is from his police report directly, where he says initially Mr. Perez did not want to talk. And then also, in some type of acknowledgement to Jose's invocation of his rights, Detective Humar says he entered an indirect line of questioning. And I highlight that Detective Humar thought it was significant to testify that these questions were indirect, as if he didn't believe Jose had invoked his right, he would have made direct questions. So I believe the evidence is clear that Jose's invocation of his right to remain silent was made. Your Honor, the 11th District has held that any statements obtained after an initial exercise of the right to remain silent are admissible only if the individual's right to cease questioning has been scrupulously honored. And of course, this is In re Gurley, 2003 case, 2003 Ohio, 1421. Gurley held that once a person has indicated that he does not wish to talk about a particular subject, all questioning on the topic must cease. And I submit that's exactly what happened here. And Detective Humar did not honor Mr. Perez's right to remain silent. The United States Supreme Court has set out an exception to this rule in Michigan versus Mosley. It's a 1975 case, 423 U.S. 96. And the Supreme Court has held that if the following factors are met, it can show the police honored a defendant's right to cut off questioning. First, if the police immediately ceased the interrogation upon the defendant's request. Second, if the questioning was resumed after the passage of a significant period of time. Third, a fresh set of Miranda warnings were given. And fourth, the second interrogation concerned a crime that had not been a subject of the initial interrogation. And I respectfully submit that none of those...
Michigan versus Mosley, those 4 factors that you just said?
Yes, sir.
Thank you.
And respectfully, I don't believe any of those exceptions apply. The first exception does not apply because Detective Humar did not cease interrogating Mr. Perez following his indication 4 separate times. One time is all he needed, that he didn't want to speak. And Detective Humar then asked Mr. Perez some general questions, not involving with the case. This went on for 3 minutes. And then what he calls indirect questions happened to discuss drug trafficking directly. This is not ceasing interrogation, respectfully. The second exception to Mosley does not apply because in that case, 2 hours was deemed to be a significant passage of time. Here, arguably there was a passage of 3 minutes of time between the third time he indicated he didn't want to talk and then Detective Humar's indirect line of questioning involving drug use. And then we have a 22-minute gap before the other detective engages his questionings and threats about ripping up the walls to Jose. Significantly less than 2 hours. The third exception does not apply, Judge, because Detective Humar did not give Mr. Perez a fresh set of Miranda warnings before questioning him again, nor did the other detective. And lastly, the fourth exception does not apply either because this interrogation involved the same subject, Mr. Perez's alleged involvement in drug trafficking. So respectfully, none of the exceptions apply.
They're not four exceptions, the thing is, those are four factors that all have to be present in order for the exception to apply.
Yes, I think I'm saying the inverse, Judge, but yes. Or at least I'm trying to. Additionally, Detective Humar's questions of Mr. Perez were encouraging him to tell his side of the story, which courts have held, specifically the 2nd District, that doing so is the functional equivalent of an interrogation, and I'm referencing State versus Kirby, 162, Ohio Appellate 3rd District, 353. And moving on to what these statements led to, Your Honor, as stated earlier, the 11th District requires officers to honor an individual's right to remain silent. And because that didn't happen in this case, he made these admissions and about where the contraband was. Your Honor, we heard today that the cocaine was very well hidden and it was concealed. There were steps involved, there were screws, there were multiple walls, pieces of the cupboard that had to be removed. And midway through the search, it hadn't been located yet. We also know that a canine, I believe, a canine was utilized and did not make any hits in the home. And just for the record, Your Honor, in order for the officers to get the cocaine, they had to remove 2 of the cupboard shelves, remove multiple screws, remove the cupboard backer, and once the backer was removed, it was in a void spot between the adjacent cupboards. And even after Mr. Perez explained this to Detective Humar had to ask several clarifying questions to convey to the officers in the room. And we know that in the home because Detective Humar testified to that today. So I believe, Your Honor, if it weren't for Mr. Perez instructing these officers how to get the cocaine, they would not have found it, and that the search would have been abandoned. Second, Your Honor.
Sure.
Your Honor, because Mr. Perez's statements were obtained unlawfully, the subsequent evidence obtained from these statements are fruit of the poisonous tree, citing Castigar versus United States, 406, U.S. 4401, and the evidence obtained must be excluded. The 11th District has held that the exclusionary rule bars not only the admission of primary evidence, which was obtained as a direct result of a constitutional violation, but also subsequent evidence recovered as an indirect result of a violation of constitutional rights. I'm referencing State versus Hardin, 11th District, case number 98-L-234 from the year 2000.
Well, let me ask you a question in terms of, I didn't see any inventory, so I don't know. I mean, your focus here is on what was located, what he told them that was going to be there. I don't know if there's other stuff that was found. If there was other stuff that was found, that doesn't come into play for this motion, correct?
Yes, Your Honor. What was
I think you're focusing on the money.
the money was part of Jose's
Right, but
disclosure.
But the money didn't require tearing apart anything, obviously, right? It was
I'm really sorry,
the
Judge.
money was in a drawer in a freezer.
Mhm. Which they had not found prior to him
I understand
telling them.
that. But what he told them, so what you're seeking to exclude based on what he said was the money and then the whatever was found behind the wall.
Correct.
Okay.
As
Anything else isn't affected by your motion. I don't know if there was anything.
No, and what I would say is, Your Honor, I'm highlighting what he disclosed directly.
That's the stuff that you're seeking to
Yes,
suppress.
which is yielding the MDO specifications
Right, I get it.
specifically.
All right, but I didn't know if there's other stuff. I don't know if there's other charges as a result of other stuff that was found. I don't know this.
My understanding is there's the one M1 with the MDO spec and the
Oh, that's right, the money, the forfeiture money thing.
that's the F5 charge.
Okay. All right, got it.
Your Honor, the United States Supreme Court has recognized 3 principal exceptions to the derivative evidence rule. They are the independent source doctrine cited in Silverthorne Lumber Company versus United States, 251 U.S. 385. Submit that none of these exceptions apply here, Judge.
This is regarding the inevitable discovery?
Yes, an independent source
I'm going
specifically.
to stop you there for that.
Yep.
And skip the argument on that. Is there any other argument you have?
Judge, for the record, I'd like to continue, but I'm going to
Well, I'm going to be having you brief that issue,
Okay.
an inevitable discovery. So you can make what argument, but I'm assuming you're just going to repeat it in your brief at a later time.
Thanks, Judge. One moment.
So that's why I'm doing it. I don't want to make it.
I understand. I will brief him, if that's a word. I will lessen my comments, Your Honor, in the name of not being redundant. I believe I've spoken clearly to the inevitable discovery doctrine not applying, based on how well hidden and how many steps were involved to reach the contraband. Judge, the attenuation doctrine, I also don't believe that applies, because the causal connection between police conduct and the evidence obtained was not attenuated, rather it was direct, and specifically because Detective Humar unlawfully obtained the statements from Mr. Perez. These statements were instantaneously relayed to the Lake County narcotics officers at the home. Nothing transpired between the admissions and the seizing of the evidence that would cause the link to be too attenuated. Rather, the link is direct and clear. So to wrap up, Your Honor, what this case ultimately comes down to, respectfully, is that the law enforcement did not honor Mr. Perez's constitutional right to remain silent. The law requires for police to stop questioning individuals once they've invoked this right. Mr. Perez invoked his right 4 times with Detective Humar, and Detective Humar understood this. Questioning should have stopped. It did not stop. And as a result of the violation, Mr. Perez was continued to be badgered and threatened about his walls being ripped apart, and he made admissions of where the contraband and the money was located in his home. But for this violation, the officers would not have retrieved the evidence, despite their warrant for the home, as we saw today just how concealed everything was. Because of these unlawful actions, Your Honor, the evidence obtained from Mr. Perez's home is tainted as fruits of the poisonous tree and must be excluded. Thank you.
Thank you. Mr. Geiger, do you follow?
Yes, Your Honor, thank you. The screws and plywood and all that and where it's located has no effect on a dog, first off. You know, the dog's not going to unscrew these plates. He's just smelled through, no different than smelling through a car, which is sheet metal and all this other stuff. And as for the defendant indicated, you know, that he didn't want to talk. There is no he's talking about 4 times. There is no evidence of that anywhere. At best, when he breaks off conversation with them and stares away or not, he doesn't say, I don't want to talk to you, ever. But the fact, then he starts talking intermittently with them about other things. So I don't think he indicated he wanted to remain silent, or else he would have. As for the search warrant not being issued already, there is no evidence of that whatsoever. Every witness testified to the fact that there was a search warrant for the house already issued before the stop occurred. The search was, whether it's midway, whether it's...
His argument to that is the fact that then why did they do an air sniff at the scene?
They had the dog there to do it.
Why? Why was that necessary?
Because they're still going to do it.
Why? If there's a search warrant.
They have a search warrant for the car, right.
So why did they have to have a dog walk around the car first?
Because if you have a hidden compartment or whatever else.
Oh, you're saying to assist with the search?
Yeah.
Okay, gotcha. All right, fair enough.
And so it wasn't that we have an impending search, so have a dog do an air sniff. It was the impending execution of the warrant, and so in case he does have a hidden compartment in the car, down deep inside the center console or something of that nature, to where it's not going to be apparent right off the bat, just like having it hidden in a wall, where the dog would find it there, where a person might pass by it. And also where he told about the currency in the home, the money wasn't found there. The money was found in a bedroom, so it wasn't found in the same place where he claimed it was. I think...
So money was not found in the freezer, is your position?
No,
That's in the inventory, right?
yeah.
Go ahead, I'm sorry.
I don't think it would be a stretch to say that he invoked his right to remain silent. He never expressively said that. And the fact that he would go back and forth and he would just turn away, then he would answer, I don't think he ever explicitly, what's that?
Your brief.
Well,
It says it.
well, it said he invoked it in the beginning, but then
It says he invoked
he
his right to remain
voluntarily,
silent.
yeah. In the be-
So you're. Never mind.
But he begins the conversation. And as for threatening or whatever, they just told him what was gonna happen. He made a logical choice not to allow it to go that far. And I'd ask you to just overrule the motion. Thank you.
Thank you. All right, this is what we're gonna do. I have considered the briefs that have been filed, motion, the brief, the response. I've considered all the testimony presented, the exhibits, and the arguments of counsel here. In regards to the first issue that was raised, this court finds clearly the evidence established was that a search warrant was issued prior to stopping the vehicle. Witnesses all testified about that, but even with Agent 91, he testified that when it was even asked of that, maybe he said, I'm pretty sure, I'm pretty clear on that, but then it was specifically asked of him, when you were sitting at the house, before you went to search the house, did you have the warrant with you? And he had the warrant at that time, and the car had not been stopped yet at that point in time. The evidence from everybody established that a warrant had been issued. Your interpretation and whatever dictionary you use to define the word impending doesn't prove what you're claiming here, that the issuance of the search warrant had not happened yet. All the evidence that was presented here indicated that the search warrant had been issued and was in the possession of law enforcement prior to the traffic stop occurring. Agent 91 testified that he was there when the search warrant was obtained. He is, in fact, the one that was given the physical search warrant. And he had that warrant with him when he was sitting on the house, surveilling the house, and the car had not been stopped at that point. So the warrant clearly had been issued at that point. So the issue in regards to the stop of the vehicle and the stop of the defendant and the subsequent search of the vehicle, the argument made in that regard is without merit, and that portion of the defendant's motion to suppress is denied. What I want the parties to do in regards to the other issues, I want two issues briefed, and just two issues. If you brief other issues, they're not going to get read. I want to know what is necessary to invoke the right to remain silent. Or I think as was said, what to indicate you didn't want to speak. What is necessary for a suspect to do to indicate he doesn't want to speak or that he's invoking his right to remain silent. That's one. And the second is I want briefing on inevitable discovery. It came up, I don't think that issue was ever raised in any of the briefs by either party. It wasn't raised by the state, which is the party that would be relying on that. They never mentioned anything about inevitable discovery in your response. So I want a brief on the law regarding that, and then apply that law to the facts that were presented here and make your argument in regards to. So in regards to what you wanted to do, you can do that in regards to inevitable discovery.
Thank you, Judge.
Because I don't have any law on that from anybody, and so That's what I want, those two issues addressed. How long do the parties need for that?
Would Your Honor consider at least 2 weeks to get the
I'll give it,
transcripts?
yeah, 2 weeks is what I was gonna give, so.
At least, yeah, I mean,
2 weeks.
That'd be fine, Your Honor.
So, 2 weeks from today, so what's today?
4th, Judge.
All right, so the end of business on the 8th. 18th, Good Friday? All right, we won't do that. I'll give you till, I'll give you a few more days then, the 23rd, Wednesday, the 23rd. And
Thank you,
business
Judge.
On Wednesday, the 23rd. Court will probably close on Friday afternoon. So. All right, anything else for the record to address for the state?
Nothing, Your Honor, thank you.
Mr. Wolf?
No, Judge, thank you.
All right, thank you.
All right.
Mary, do you have these, or are these just my copies? You have those. I'll pop them right there. I see them.
defendant is present with Jim Matthew as counsel. A one-count indictment was returned against the defendant on March 28th, that one count being aggravated possession of drugs, a felony of the 3rd degree. The state is recommending a bond of $15,000, cash surety 10% in this case.
15?
15, yes.
So you're increasing it from community court?
Yes.
Mr. Maureen, you have been indicted by the grand jury on one count indictment. Did you receive a copy of that indictment?
Yes.
Had a chance to look that over? Did you have a chance to look that over?
Yes, Your Honor.
Now, you have a right to have me read that indictment to you, and I'm more than happy to do that, but you can also waive the reading and if you want, which means you don't care to have me read it to you. What would you like me to do at this time?
You can wait.
Waive it?
Yeah.
Okay. Then as to this one count of aggravated possession of drugs, a felony of the 3rd degree, what is your plea at this time?
Not guilty.
Court will enter a plea of not guilty. Mr. Matthews, you want to be heard on matter bond?
Yes, Your Honor, thank you. Mr. Maureen resides at 836 East 155th Street in Cleveland. Are you working, Mr. Maureen?
Yes.
And what is it that you are doing?
I'm home, self-employed, and I work for.
He is self-employed, Your Honor. He has spoken with Attorney Bill Watson and indicated that he would be able to post a bond of $7,500, 10%, were the court to set it at that amount, Your Honor. Thank you.
Ms. Bell?
Thank you, Your Honor.
Please, for the state's request.
Thank you, Your Honor. So this offense, aggravated possession, but at the time the defendant gave a false name to the police that were investigating it. He has a pretty lengthy criminal history, mostly drug-related, some trafficking. And he has a pattern of failing to appear. There's at least 2 that I've been able to see. Also during this incident, there was a child in the car and an open container of alcohol. And he's been to prison 1 time previously. So the state believes that increase to $15,000 is appropriate. Thank you.
Court's going to reset bond at $7,500, 10%, cash surety 10%.
Thank you, Your Honor. All right, so you bond $7,500. Okay.
He needs to sign this bond condition form.
I have his signature on one
Oh,
right here.
does it have the correct information at the top of it, like the caption?
Right?
CR 296.
Yeah, 296. You got
I
it.
believe that is, what is your zip code in Cleveland?
44110.
What did I say? That's the old
Yeah, can they stick around so I can get a little bit more information? I need to sign that, I'm sorry.
Yeah, they can wait a few minutes.
All right.
Got it?
Yes. Thank you, Your Honor.
What was your next one?
Was,
Overall?
Trina.
Overall? You can sit here.
Thank you.
Which one waived? Anderson?
Oh, Newsick.
Oh, Anderson. So you got the paperwork for that?
Yes.
I
Yes,
can show
yeah,
this to
I
them.
had already given that paperwork.
All right. It's right here, I'll just throw this away. All right.
Yes. Thank you.
All right, who has this over? Ms. Bell?
Thank you, Your Honor. So we're here again for the in-court arraignment of Treva. Overall, that's case number 25CR188. This was a secret indictment returned against the defendant on February 12th, 2025. Count 1 being forgery, a felony of the 4th degree. Count 2 being theft, a felony of the 4th degree. Count 3 being theft, a felony of the 4th degree. Count 4 being telecommunications fraud, a felony of the 4th degree. And count 5 being identity fraud, a felony of the 3rd degree. The state is recommending a bond of $25,000, cash surety 10%. Thank you.
So overall, you've been indicted by the grand jury in a 1, 2, 3, 4, 5 count indictment. Did you receive a copy of the indictment?
Yes, I did.
Had a chance to look that over?
Yes, I did.
Would you like me to read that indictment to you, or do you want to waive the reading of the indictment?
Waive.
Very well, then, as each of the 5 charges in this indictment, how do you plead?
Not guilty.
The court enter a plea of not guilty. Mr. Matthews, did you want to be heard on bond?
Yes, Your Honor, thank you. Ms. Overall, it is true she was extradited from the state of Tennessee. She indicates she was there visiting her brother. She does reside permanently at 315 5th Street in Fairport. She is not currently working, but is requesting an own recognizance bond. She indicates that she has a hernia surgery that she previously scheduled on April 23rd. And as the jail is aware that this is a previously scheduled surgery, I did speak to the dispensary, and they indicate that they will not be transporting her there and bearing the expense of said surgery. So Ms. Overall would, if she is to have the surgery at the time that it is scheduled, need to be out for that, Your Honor.
Ms. Bell?
Thank you, Your Honor. So Ms. Overall does not have a lengthy criminal history. However, she does have a unauthorized use of a vehicle back from 2023, and that's really where the problems begin. For that case, she failed to appear for her trial, and then was ultimately sentenced, and then got a probation violation for leaving the state of Ohio without permission of the probation department or the court. And for those reasons, and there is some indication that her housing is not exactly stable, and for those reasons, the state would ask for that $25,000 cash surety bond. Thank you.
Well, problem with Ms. Overall is it's not the first time that every case you've had here, you've failed to appear in court. The first case you had in Lake County ultimately was Nolly, but you still failed to appear in media court when you were first charged after you were reduced from a $120,000 bond to a personal bond. You did show up. That case gets dismissed, and you pick up a new charge, and you leave the state of Ohio, and you have to be extradited back at taxpayer expense to come back here. Ultimately, you went to prison because you couldn't follow conditions of probation. And then you pick up this offense, and again, you had to be extradited back. And I'm not going to continue playing these games, having to extradite you and spend thousands and thousands of dollars to get you back here, because there's no question, if I let you out, you're going to be gone. So I'm setting bond at $100,000 cash surety. Next case is Anderson.
Just as they want. Trevor, I need you to sign that right there.
Here's the order of conditions.
This is the address where my daughter is. My sister is there. My sister.
So,
40.
I have some information on my phone.
All right, who is David Anderson? Leslie?
Yes, Your Honor, thank you. This is State of Ohio versus David Anderson, case number 25 CR 159. Defendant was indicted in a 4-count indictment on March 14th of this year. The state is requesting a bond increase from $5,000 cash surety or 10% with the condition of no contact to $10,000 cash surety or 10% with the condition of no contact. And I'd like to be heard in regards to that increase at the appropriate time.
Thank you. Mr. Anderson, you have been indicted by the grand jury in a 4-count indictment. Charged with passing bad checks, forgery, theft, and theft. Each of these are felonies of the 5th degree. Did you receive a copy of this indictment?
Yes, I did.
When did you get that? When did you get that? I'm sorry.
Just Tuesday I got it.
Tuesday?
Yes,
Okay.
I did. Yes.
You had a chance to look that over? Have you had a chance to look
Yes,
that
I
over?
did. Yes.
Any questions about it?
No,
Now, you have the right to have me read it to you, and I'm happy to do that, or you can waive the reading of it. What would you like to do at this
you
time?
can read it to me. Yes. You can read it to me.
You want me to read it to you?
Yes.
I'll read it to you.
Okay.
Yeah.
Count 1, it's alleged that David G. Anderson, on or about July 13th, 2024, in Willoughby Lake County, Ohio, did with purpose to defraud
issue or transfer, or cause to be issued or transferred a check or other negotiable instrument, specifically is it GISA or GISA? You don't know? GESA Credit Union check dated July 10th, 2024 in the amount of $4,500, and that David Anderson knew it would be dishonored or knew that a person would order stop payment on the check or other negotiable instrument. The check was issued to a single vendor or person for payment of over $1,000. That constitutes the offense of passing bad checks, a felony of the 5th degree. In count 2, it's alleged that David G. Anderson, on about July 13th, 2024, in Willoughby Lake County, Ohio, did with purpose to defraud or knowing that he was facilitating a fraud, uttered or possessed with purpose to utter a writing being GISA Credit Union check, and that you knew it had been forged. It constitutes the offense of forgery, a felony of the 5th degree. In count 3, it's alleged that David G. Anderson, on or about July 13th, 2024, or on or between, I should say, July 13th, 2024 and August 5th of 24, in Willoughby Lake County, Ohio, did with purpose to deprive CheckSmart, Buckeye Check Cashing, the owner of property, being U.S. currency, knowingly obtained or exerted control over that property or services beyond the scope of the express or implied consent of CheckSmart, Buckeye Check Cashing, who was the owner or person authorized to give consent. The value of the property involved was more than $1,000, which makes the offense theft a felony of the 5th degree. Lastly, in count 4, it's alleged that David G. Anderson, on or between July 13th of 24 and August 5th of 24 in Willoughby Lake County, Ohio, did with purpose to deprive CheckSmart, Buckeye Check Cashing, the owner of property, being U.S. currency, knowingly obtained or exerted control over that property by deception. The value of the property involved was over $1,000, making the offense theft a felony of the 5th degree. So, Mr. Anderson, as to these 4 counts, what is your plea?
Not guilty.
For one or plea of not guilty to each of those 4 counts. As to bond, Ms. Alessi.
Thank you, Your Honor. As I stated, bond was previously set at $5,000 cash, surety, or 10%. The arraignment in this case was originally scheduled for March 28th of 2025. There was a failure of service and a warrant was issued. The return of service on that summons said bad address, moved out in January. That address that the state had attempted to serve the defendant at was the same address that the defendant had been reporting to his probation officer, Nicole Newman. The defendant was on probation to Judge Condon's court for an attempted menacing by stalking, a felony of the 5th degree. The probation officer, Nicole Newman, had confirmed that address, and that was the address that he had reported since he had been reporting on probation to her. Upon learning and looking into this further, the state spoke with Ms. Newman, who indicated she had even confronted the defendant on April 2nd when he came in for a probation meeting. And
2 days ago, April 2nd?
Yes.
Okay.
He had actually confirmed that same address initially, indicating he was living there. Upon the defendant's statement, Ms. Newman indicated, no, you're not. We know you're not living there, at which time the defendant admitted he had since moved with his sister. He was unable to give a full address, and that his sister was living in Richmond Heights. At that time, the defendant was taken in on the warrant on the failure of service. Also, since that time, probation or the state has filed a motion to terminate in that underlying case, the menacing by stalking case, for the probation violation being he's not reporting a current address to the probation department. So he is being held on that case as well at this time. So the state thinks this does warrant a bond increase, even though he's being held on the other case. So we're requesting the $10,000 cash surety or 10% with the condition of no contact with the victim.
Mr. Matthews, care to be heard?
Yes, Your Honor, thank you. Mr. Anderson is Rachel Smith's client. She sent me some information indicating that he is merely requesting that the bond be continued at its previous level, and that she does intend to request a bond next week when the probation case is going to be heard. She indicates that he owns his own business and that he is now living with his sister in Cuyahoga County, and that he has been in regular contact with her multiple times a week by phone and has appeared at 2 office conferences. The new address is, this says Foxy.
Foxwing Trail.
Why did he lie to probation about his address?
I
Where he was living?
cannot speak to that, Your Honor. Would you, Mr. Anderson, care to speak to?
No, he probably shouldn't. There's a probation
Okay.
violation pending on that, so.
A good point. But he does have an address in Richmond Heights, and given his appearance at office conferences, appears to have the ability to make it to Lake County, Your
Well, obviously, the purpose of bond is to assure folks' appearances, and the way that happens is by sending them notices of hearings, and when people aren't being upfront with the courts and that, and he was given an opportunity, actually, before he was even confronted with the fact that they knew it was not accurate. That defeats the purpose. I'm going to reset bond of $10,000 cash surety or 10% with an order that they have no contact with the victim. You have a form for that? Bond condition form?
On condition, I think it's what he's doing.
Yes, we are working on that
Right.
right now.
Anything else for the record on this case?
No, Your Honor, thank you.
All right, thank you.
All rise.